careful how I proceed. So I want to make sure that everything I say and do, I do it correctly and properly, and so that I know. Okay, hopefully that's muted and people could hear. Hold on, let me go live. Okay, hopefully people could hear, guys. So sorry about this. Like, it's been a while since I go live and stuff like that. So I'm trying to make sure that everything is done correctly and properly. Hey, how are you? If you guys go into my YT channel, you'll be able to see everything. Um, I'm trying to do everything like I used to, just so everything is just so annoying. Tickety tockety has gotten me so annoyed. So I am MamaFlipSlots. I need to be very careful with my videos because Tickety Tockety has decided to give me a strike. And as a result of the strike, I have to be extremely careful of how I decide to proceed. Okay? So just in case if you guys want to know what's going on, that is what's going on. We want to be very careful of how we decide to proceed with stuff. Okay? So that's one. Two, I have several things live. I want to make sure I have everything here. Okay, great. Everything's here. I just want to do one more thing. So, as I'm sure many of you guys already know, I'm going to be speaking in certain slangs because I want to make sure that I don't do anything that would generate some type of additional. Oh, so Nicki Minaj says she's gonna sue Cardi B, huh? Wow, everybody's suing everybody nowadays. It's nice to be able to sue when and then other people have their First Amendment rights removed from them, and other people who has money could sue. It must be nice. The rest of us get in trouble all the time for the things that we say, and you know what happens is that when we say stuff, people say that we're wrong. So anyway. Give me a second, guys. I'm just trying to share this on my other channel. All right, just share it. Please go to Flip Line to hear the latest. Thank you. All right, so I just wanted to post this. We post that. Everything is mute, 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 mute. Is it? It's easier. Let me tell you something. Hi, attentively, Lola. Lola, how are you? Long time no see. Guys, it's so much easier. I could tell you it's so much more easier when you if you could do all of this stuff prior to your life, which you can't. You could only do it in your life. So that's why there's a massive delay, because you can't do any of this outside your life. Let me make sure that Tickety Tockety could hear me. I think I made, let me confirm that real quick. Tickety Tockety, we got to be very careful with the way we talk, unfortunately, because our friend, okay, because our friend Tickety Tockety and all the community guidelines that they put in place, we want to make sure that we do not actually go against the guidelines. Okay, so I will say very nicely that if I'm going to, I probably would have to mute you guys and when I actually start reading some of the documentations. And if you can, please come to my YT channel. My YT channel, we are there now, and you would be able to see everything and hear everything. because when it starts getting juicy, I'm gonna have to mute Tickety Talk, because Tickety Talk doesn't appreciate all free speeches. Okay, they feel that it's against the rule. So first of all, so all the receipts that I'm showing, I'm gonna actually be showing on our YT house. So please come to our YT house. It has the same name, Mama's Flip Lives, and we are currently there right now. Okay, so we're gonna start with what's happening. So what's happening is today we received notification that there was a denial. And what was denied? Again, Tickety Talk, if you'd like to see what we're talking about, please go into YT. Okay, so um, Mr. Combs was denied. Okay, it was reported in the news, NBC News. I'm going to read the article real quick. The judge in the Sean Diddy Combs case rejected the hip hop mogul request to toss out his tuition related conviction Tuesday, setting the stage for his hearing on Friday. U.S. District Judge Oran, right? I want to make sure I be careful with names that I use, just in case if it triggers something with Tickety Talk, who oversees the Combs 8-week trial in New York this summer, turned down Combs motions to throughout his eviction on 2 counts of traveling to engage in tuition, which each carry a maximum of 10 years. Combs, the founder of Bad Boys, is scheduled to be in the hearing this Friday, and I'm planning on being there. Unfortunately, if I'm there live, I can't take the chance of actually going live there on Tickety Talk, because the last time I did that, I got my first warning. Now I have a strike. So unfortunately, we got to be very careful of what we show on Tickety Talkety. But however, I will be going live on my YT when I'm there at the house. The lawyers for the government has accused Combs of orchestrating a decade-spanning enterprise. Okay, I'm gonna stop it here. Stop sharing it on YouTube, because if you guys want to see it, please go to NBC News. Again, I am using the copyright doctrine in order to share these receipts, but I don't want to show the whole thing, so I'm going to continue reading. Okay. So everybody who comes in on YouTube, thank you for coming into YouTube, Instagram. If you're here, thank you. Enterprise and forcing women to participate in marathon rug days, actual encounters with squats known as FOs. Okay. Combs, who has been held in a Brooklyn jail cell for more than a year, pleaded not guilty to all 5 counts in the heart of the trial, and he had denied the allegations. Jurors acquitted Combs on 1 count of rack conspire and 2 counts of traveling by I'm sorry, I'm removing letters, guys. Fraud and coercion, denying prosecutor a verdict that could have sent him to the upstate college for the rest of his life. He was found guilty on charges under what is formerly known as the Mann Act, a federal law passed in 1910 that outlaws moving people across state lines for not great purposes. Combs' lawyers argue at a hearing on Thursday that the act didn't apply to their client, in part because he wasn't running a commercial business. They also insisted that the the prosecutor, I'm just going to use the name, key witnesses, including ex-girlfriend Cassandra Cassie Ventura and a woman identified by the pseudonym Jane, willingly participated in the FO. And again, I'm going to say this very clearly because a lot of people don't want to hear it, so I'm going to tell you. I've attended every single day of that trial. They did not willingly participate in all of the FO. They did not. Okay? I'm just saying. I don't care what the judge, what other content creators say. I don't care what Mark, the famous lawyer, said. When there's like, oh, if you say, no, it wasn't him. It was one of the content creators that was in trial that was like, oh, if you say yes 75 times, why should somebody hear you if you say no in 76 times? It's the most, all due respect to her, that's the most ridiculous reason I've ever heard in my entire life. But that's where she stand. Either way, they said no several times. Text messages, regular messages, voicemails, they said no several times. I'm just saying, okay? We are talking about adults having a threesome, number 3, bring other adults into their ex-life. Alexander Superior, one of Combs' defense, told Sambramania. I shouldn't know the judge name. I shouldn't get to know because I really especially depending on how he rules on Friday. I need to know his name. The prosecutor tried to rebuff the narrative, telling let me just call him Sub, that the government has an important and substantial interest in cracking down on exactly the kind of interstate tuition Combs was accused of orchestrating for his actual encounters. The government proved the defendant transported Cassie, that's traveling Cassie and Jane, both domestic and international, so they could participate in tuition. Assistant U.S. Attorney Christy Slablak said the FO were about one thing: his actual gratification, his personal pleasure. Submarina previously denied Combe effort to be released on bail, saying in part that he fails to satisfy his burden to demonstrate an entitlement to release. So that's the letter. He said no. Now I hope that the judge would have denied it. I said in an interview after that hearing that I would have been very surprised if he was released. To be honest with you, I would have been very surprised because no matter what a lot of people say, a lot of people feel that that this what happened was not important. What happened was just a small situation, and that it shouldn't have been brought on trial. They said a lot of things. A lot of people give a lot of reasons and excuses for this guy because he's famous. That's what it is. A lot of people give a lot of excuses for this guy because he's famous, and there are his supporters. What a lot of people don't understand is that what he did, even though he believed that he had a right to, impacted a lot of people in a horrible way. He was found guilty, right? And no matter what anybody say, he was found guilty, right? And he should, pay the consequences. Period. So anyway, let's look at the actual documentation that was actually submitted by our judge. Okay. All right. Again, if you would like to see these documents and stuff like that, please go to my YT page. I will have them displayed. I'm bringing them up now. I'm sorry, guys. I'm bringing them up now so you guys could see If you like to see it, please go to my YT page so you can see it, so you can read it along with me. Okay? I'm going to read it right now. United States of America versus Sean Combs. In the case 24 CR 542 AS, opinion and ordered. Judge Iran, let's just call him Judge Iran. After an 8-week trial, a jury convicted Sean Combs of 2 counts of traveling people for tuitions under the Mann Act, DK 447. Before the government rested its case, Combs moved for acquittal under Rule 29 TR 7352 Fed R Crime P29. The court reversed its decision under Rule 29B, and Combs renewed his motion after the verdict. TR 7391 DKT 485, I'm guessing that's docket. He also moved for a new trial under Rule 33 DK 485 Fed R Crime P33A. For the following reason, both motions were denied. Let me tell you something about this man. Let me tell you something about this judge. This judge don't play. This judge, I love it every time. I'm hoping that he doesn't. I hope that he give me a little time to get there, because I got to get there very early in the morning, make sure that I am in that room. I'm going to get there early because I want to be sitting here in that room this Friday. I love this judge. This judge come in 2 minutes and say 3 sentences, and then he says denied. I love it. Every time he comes in and he get a case, he says 2 or 3 sentences, and then he write denied. The whole paragraph's not even finished. He ends it with the answer, and then he explains himself. I love that about him. Hey, Nick Nack, thank you for being here. Thank you for the heart. I love that about this judge. He doesn't waste any time. I love it. Guys, as you come in, please tap. I really appreciate you guys. I am reading the documents, the denial. If you would like to actually see it, please come to my YT, because unfortunately I can't show it here. And I'm not going to even turn the camera to show it because, again, Tickety Taka has decided to give me a strike. And I'm not playing with Tickety Taka for 6 months. And I should tell you, when it comes to Tickety Taka, even if you don't know, if they give you something for 90 days, and after 90 days it's supposed to fall, right? And you're not supposed to do anything in 90 days. I didn't realize that it's 90 days, and then after the last day where the warning drops, you can't do anything for another 90 days, because if you do anything for another 90 days, then you could get a strike. So technically the punishment is not 3 months, the punishment is 6 months. I think they should make it a lot clearer. Maybe everybody know it. I did not know it. So anyway, here we are. Also, be careful when you hashtag people name, even though you don't know the person is an issue on Tickety Talk, because they didn't tell you they're an issue. Be careful in hashtagging. So anyway, let's continue. I love Judge Iran. I said Iran because Judge, he don't play. He lets you know straight up whether it's going to be accepted or denied. I love that about him. Give me 1 second, guys. Give me 1 second. Sorry, guys. Okay. I'm back. Oh God. As soon as I come back, I lose my thing. How is that possible? Sorry, guys. I gotta now put in the background again. What is happening with this? I apologize, guys. Give me 1 second. It looked like they changed this thing. We've never had to do it twice. As long as the effect was there one time, that's all we needed to do. We didn't have to do the effect over and over and over again. That's silly. Hold on 1 second. Tickety talk. I have to put the effect back on. It's been a rough past few days, guys. Many people annoying the hell out of me. Just want to take a break from it all. All right, guys. Thank you. Hi, how are you? That's ridiculous. Why would I have to do it again if I'm in the middle of the live? That doesn't make sense. So anyway, let's read. Okay, so what I'm doing right now is I'm reading what the judge had to say. The judge said denied. So let's continue to see. If you are on YT, if you like to see what was written, please join us in my YT house. It's the same name. You'll be able to see the document in the YT live. Okay, so let's go. Now I'm just trying to get to it, guys. Okay, denied. Background. The government first indicted Combs in September 2024 for a violation of the Mann Act for traveling and for tearing conspiracy, Dr. Two. In its third and final indictment, the government case was built on Combs' action beginning in 2004 and continuing over the next 2 decades. Dr. 209-16-13-17. The government alleged that Combs arranged for and paid males to travel across the U.S. and intentionally have sex with Combs' girlfriends, Cassandra Ventura and Jane. ID 121820. Further, the government alleged that Combs transported Ventura and Jane to have sex with those men, gave them rugs, and physically pow them with the hand. This, the government argued, was all the product of the Combs enterprise, a criminal organization compromise of Combs, his businesses, his employees, on the government, telling the organization exists for a lot of reasons, not only to run a global business in the media, entertainment, and lifestyle industry, but also to fulfill the personal desire of Combs, particularly those related to Combs' sexual gratification. Exactly. So a lot of people keep talking about how, the government was talking about the Combs businesses. They shouldn't be in the Combs business. He was doing more than just he was doing more. He was a businessman. He was a man of excellence. The government railroaded him. The government specifically said, and I said it over and 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 over again. The government specifically said when they talk about the Combs enterprise, they're not talking about his business. They're talking about the fact that he had he used the business, his employee, to actually set up this lifestyle to actually for his own purposes. That's why they call it the Combs enterprise, because he used all factors. They're not talking about his only business was to do that. This is why they said clearly, we're not talking about him as a businessman and said that he only did that and he did nothing else. We're saying that he used the business, his employees and other things to create an enterprise in order to fulfill this his gratification. And the judge noted that in his decision. The case went to trial. After the government arrested Combs, moved for acquittal, TR 7352. That motion focused mostly on the tearing and the traveling, but also contested the Mann Act charge, TR 735291. With respect to the Mann Act, Combs argued that the escorts, that's the men, who testified didn't travel across state lines, that they disavowed that they were paid for X and engaged in tuition, and that they sometimes were paid even when they didn't have X. Lord have mercy, Christ. So when he asked Dave to travel, I think it was Dave to travel from New York to Miami, that's not crossing the state lines. There was a guy called I think his nickname was LA because he refused to leave LA. But it's not him I'm thinking of. I'm talking about his body, his trainer. His trainer went from LA, he went from New York to Miami. They had the receipts, and he went to Turks and Caicos. So you telling me that all these receipts, all these documentation, which prove that these people traveled back and forth, um, was false flag, huh? Okay, let's continue. The jury agreed with Combs about the traveling and the tearing charges, acquitting him of both. DK 447, but it disagreed with Combs about the Mann Act, finding him guilty. Combs now renews his Rule 29 motion and also moved for a new trial under Rule 33, docket 487, Fed R, Crim P 29C1 33A. Legal standard. On the defendant motion, a court must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain the conviction. Fed R crime B29. Evidence is insufficient to sustain a conviction only if it is non-existent or so meager that no reasonable jury could find guilt beyond a reasonable doubt. United States versus Cuddy, 7E3D 453 461, Second Circuit 2001, citation omitted. As the Second Circuit has explained, a defendant challenging the sufficiency of evidence bear a heavy burden because the reviewing court is required to draw all permissible inferences in favor of the government and resolve all issues of credibility in favor of the jury verdict. United States versus Konzini, 667 F3D 122 139, Second Circuit 2011. Under Federal Rules of Criminal Procedures 33, upon the defendant motion, the court may vacate any judgment and grant a new trial if the interests of the justice are required. Fred R. Grimm, B33A. Generally, the trial court has broader discretion to grant a new trial under Rule 33 than to grant a motion of acquittal under Rule 29, but it is nevertheless must exercise the Rule 33 authority sparingly and in the most extraordinary circumstances. United States versus Ferguson 246 F3D 129 134, Second Circuit 2001, quoting United States versus Sanchez 969 F2D 1407 1414, Second Circuit 1992. In the exercise of its discretion, the court may weigh the evidence and credibility of witnesses. At the same time, the court may not wholly uphold the jury rule. United States versus Ottorio 212 F3D 105 120, Second Circuit 2000. Internal citation omitted. The defendant bears the burden of proving that he is entitled to a new trial under the Rule 33, and before ordering a new trial pursuant to Rule 33, a district court must find that there is a real concern that an innocent person may have been convicted. Lord have mercy, Christ. United States versus McCounty 562 F3D 452 475, Second Circuit 2009, quoting Ferguson 246 F3D at 134. Accordingly, the court must examine the entire case, take into account all the facts and circumstances, and made an objective evaluation, keeping in mind that the ultimate test for such a motion is whether letting a guilty verdict stand would be manifest injustice. Would be a manifest injustice. A manifest of injustice? Manifest injustice. United States versus Landsman 14F4 298 330, Second Circuit 2021, quoting United States versus Allison 889 F3D 135 146, Second Circuit 2018. Discussion. Let me tell you something. These his lawyer threw everything in the kitchen sink. They just kept on going. They just kept on throwing everything. They spent the entire time celebrating the fact that they only got 2 of the charges versus all 5. Man, it's been an entire time talking about how it wasn't a big deal. And now they're crying about it. And they want it to be reversed. After they said that it wasn't a big deal. So discussion. Combs make 2 type of argument under Rule 29. Legal ones about the correct definition of tuition, which is crazy. That argument was so crazy. I didn't even go on live after the last hearing because it was just too much for me. I just wanted to see what the judge came back to it because it was too much. This man proceeded to talk about how it wasn't tuition, it was it was just actual curriculum between 3 consenting people, and that it wasn't a big deal, and that he didn't really pay for it. And because he didn't pay for it and the ladies paid for it, then technically he was just an observer. He was just watching. And they also continued to say that this man was an amateur corn producer. So now he's going into the cornfield. So he's a corn producer. So he did not participate with the actual males, so it's not tuition. So the judge said very clearly to Miss Shapiro, I'm not even going to look her name up again. I think it's Alexander Shapiro. He said, so if you have 2 businessmen and one businessman hires a tuition for his client, the second businessman, right? And he pays for it. That means the businessman paid for the client, paid the tuition to have actual relationship with the client. Guys, I hope that you guys understand it because I am on TikTok. I'm also on YouTube. We want to be careful of the wording. Just add a letter to everything that I say. He said, are you saying that's not tuition? That's what the judge said. So I already knew when the judge was listening to their BS that he was just like shaking his head. He's like, so you're saying that's not tuition? And they had the audacity to come out and say, well, judge, yeah, maybe that's not tuition. Maybe it's not tuition. Maybe it's different. Maybe it's a different opinion. Maybe it's a different circumstances. Maybe. So the judge already knew, like, he was like, okay, this is ridiculous. So I'm hoping he details here exactly how he took what they said in court. Cause I was like, yo, this part right here is ridiculous. Y'all throwing everything. Y'all throwing everything against the wall. So anyway, he agrees that the evidence of the acquittal count prejudice. Okay, so Combs had to the factual ones about the evidence. In Rule 33, he argues that the evidence on the acquittal court prejudice the jury on the counts of conviction. He made 2 types of argument: legal one with the correct definition of tuition, and factual ones about the evidence at trial. On Rule 33, he argues that the evidence on the acquitted counts prejudice the jury on the counts of conviction. So what that's saying is that he's saying that because they acquitted him on 3 other out of the 5, right? That the judge should not use any of the evidence that was compiled of the original 3 case. I mean, the 3 what do we call charges? Thank you. They shouldn't use the evidence of the 3 charges in which he was found not guilty. It's unfair. It's prejudicial to make a decision in regards to the Mann Act. That's what he said. That's what the lawyer said. The lawyer said, because he was acquitted. Like, for example, because he was acquitted on the traveling, right? They shouldn't take all the traveling, right? They shouldn't, because the traveling, because no, I'm sorry. They did find him guilty of the Mann Act, which is traveling, but I'm thinking of the rack, and I'm thinking of, sorry guys, I just want to read it. Give me 1 second. I want to make sure. Okay, thank you. Not 4, it's 3, you stupid. Anyway. Okay, so so I was right. The traveling, okay, because he was found guilty. He wasn't found guilty on the racket, the spree, and the X trafficking, right, which is traveling, right? Because he wasn't found guilty, they shouldn't use any of the evidence on the first 2 trials, right? The jury should not have used any of the evidence to find him guilty on the actual traveling and engaging in tuition. That's what they said. That's what they said. So everything that was said that had anything to do with the tearing, even though the whole case is a whole story of his life and everything he's done. So if anything was said to prove or to try to prove the rack and the X traveling, it should be thrown out. It shouldn't be considered. That's what he's saying. So let's see. Let's continue. Rule 29 legal argument. The legal argument in Cohen's Rule 29 motion turns on that the word tuition means in the Mann Act, the act has 2 clauses. Both share the same act element. Transporting someone in interstate of foreign commerce, 18 USC 241, but they have different intent requirement. The first clause, the one at issues here, requires that the defendant intend that the transport person engage in tuition. The second clause, a broader catch-all, requires that the defendant intend for the transport person to engage in any actual activity for which any person can be charged with a criminal offense. Together they read, whoever knowingly transport any individual in interstate or foreign commerce or in any territory or possession in the United States with the intent that such persons engage in tuition or in any actual activity for which any person can be charged with the offense. At trial, Cohn proposed that the jury instruction defines tuition as engaging in actual activity for money or its equivalent. Yeah, they kept on saying that the tuition was like he engaged in for money, right? So meaning that somehow he either was, because the guy he's implied that some of the guys said that they weren't paid or they were paying more, and sometimes they wasn't paid for not doing certain things, that technically they wasn't technically really paid for the act. That's what it's saying here, engage. So he's saying that the definition that proposed that the jury instruction definition as engaging in actual activity for, that's what it means as far as tuition. Doc 27 at 56, citing Black Law Dictionary and state law definition. The court adopted Combs' definition in its instructions to the jury, which proceeded to convict Combs under that definition. So the judge is saying that now they're the one that gave him the definition. See, this is where Sean Combs prosecutors kept doing this throughout the trial. What they would do is they would say something or submit some wording, and once it's approved or agreed on, they would reverse and said that it was wrong. They've done that several times. And another thing that they would do is that they would say that they submitted a document, right? But they didn't submit all the documents. Like they were supposed to submit 6 pages. So instead of submitting 6 pages, they submit 4 pages. They forget the 2 most important pages, and they be like, "Oh, my bad, I didn't submit it. Oh, wow, I thought I did. Oh, my bad. I'll go back." We spent hours listening to them with this BS, like, And one of the things that pissed me off about the case is that they were able to get some very important testimony from Jane thrown out because it was after he was indicted, and they thought it would be prejudicial, which is, to me, was BS because it tells the whole story. But anyway, this is a prime example of what I said before in some of my lives. You see, they are the one. Combs proposed that the jury instructed the Constitution as this. They are the one that gave the definition using Black Law Dictionary, state law definition. The court adopted Combs' definition in its instruction. They took Combs. And with that definition, he was still convicted, right? So now he argues that his proposed definition was all wrong all along. Now he argues that his proposed definition was wrong all along, and that it should have not been considered. So that's his argument right now. So everything, my bad, Judge. We gave you the wrong definition. Yeah, I need a new trial. Okay, so let's continue. Let's continue. This is just the beginning, because I want to read everything that said, because I said it over and over again. A lot of people didn't agree with me, especially a lot of internet lawyers, especially some of the actual lawyers. I said to them over and over again, the way I'm reading the judge, and again, just because I'm saying it doesn't mean that I know what the sentencing is going to be on Friday. I don't know. I respect the judge. I think the judge is taking everything into consideration. But again, we are living in a powerful political world right now. And I keep saying it over again. And some people say, I never said it. And I'm going to say it over again until people hear what I'm saying. We're living in a political powerhouse right now where these type of cases are not as important, in my opinion, than they used to be. So I don't know if the judge would consider that at all, right? I don't know if the judge would be careful, because this is probably one of the original case like this, and he may not want to give him the whole amount of years that even probation say he should get. I don't know. He doesn't seem to be the type, but he's not unintelligent either. He doesn't want to give him too much time, so if he appeals it could be thrown out. So the judge have a lot to juggle. But I've said it. With that said, I don't know what the judge is going to do. I said I'm very confident in one thing: the judge did not agree with the juror. I said that over and over again. I said, based on what the judge said when he denied the original bail, the judge did not agree with the jurors. The judge and I, and a lot of people who don't want to see it, saw a lot more evidence provided to him. He read everything, he's seen everything, stuff that was removed from the jury's preview. The judge saw everything. So the judge is not only going to make a decision on what the jury saw. That's ridiculous. That's silly. The judge has to make a holistic view and make a decision based on everything that he saw. Right? The judge disagreed, in my opinion, with the juror. I could see it. I disagree with the jurors. I think the jurors was out of line. I think the judge I feel that the jury put the blame mostly on the women. So let's continue reading. Again, this is just one of the BS that Combs and his lawyers try to play. They will give a definition, fight to make sure that the judge put the exact definition, because they were fighting back and forth about what to tell the jury before they went to deliberate. They the one that gave the definition based on black law dictionary and state law. And now, after they gave the definition, the judge took them the definition, gave the jury the definition of what they're actually going to be reviewing in order to come up with the decision. After they still found him guilty based on their definition of what tuition is, they're not saying that the definition was wrong all along. Tuition, he says, intent requires either that the defendant have a commercial motive, that the buyer has X with the seller, or both. Idea 25. That would mean that there were never any tuition involving Combs who lacked a financial motive and didn't directly have X with any of the males he hired. Now you see how the judge put he hired, because a lot of people are saying that it's the women that hired the guys. I've said it 1,000 times. The women did not hire them exclusively. I said it 1,000 times. The women did not have the money to pay for this type of lifestyle. He gave them the money. His people dropped off bags. Okay? It was proven. There were receipts. So they did not hire. They made the call, but they did not hire the people. And also, he also made calls. He also worked with the lady, I forgot her name, Cowboys and Angels, I believe. Cowboys and Angels, I forgot her name. Was it Rachel or Richard? Whatever her name is. I got to remember everybody's name now because it's been such a long time. And I really don't want to keep all this information. But I remember Cowboys and Angels. I believe it's Cowboys and Angels. He had phone calls, texts between the owner of Cowboys and Angels to make arrangement himself. Those were provided. But because the women made the calls, and most of the time made most of the calls because he was trying to cover his behind, they are being blamed. And the judge says here clearly in his statement that he is trying to say that he didn't directly have X with the men he hired. There's a lot of nuances when they come to this judge, man. I'm gonna hold my reservation to say if I totally love him based on what he does on Friday, but there's a lot of nuances. This judge is not one to play with. When I tell you this judge is not one to play with, he's not one to play with, ladies and gentlemen. He's not. So let's continue. On his telling, applying a broader definition would create a constitutional problem. These arguments don't hold water for the following reasons. All right, guys, give me a second. I have to run to the ladies' room. This is taking a lot longer than I anticipate. Oh, shoot. I didn't even know my camera wasn't on. This is taking a lot longer than I anticipate, but I want to read everything. Not only am I going to read this, I want to read the letters from the ladies, too. So, second, I'll be back. Hi guys, I'm back. Sorry, I had to run to the ladies. Give me 1 second. Now I gotta put this back. Sorry guys. It used to hold these backgrounds. Maybe I'm using the wrong one, but it used to hold these backgrounds, and now it doesn't. Maybe I'm afraid to use his picture, but I'm gonna put his picture up. Let's see if they allow it before I get in trouble, because I am talking about him. Give me 1 second, guys. I'm gonna put his picture up until they give me a hard time, so everybody know who we're talking about. It's easier. Here it is. Okay. All right, guys. Let's see. Let's see if they have a problem with it. Meaning, I'm talking about Tickety Talk. If they have a problem with it, then I'll remove the picture. Knowing my luck, they behind would kick me out anyway. So let's continue reading. So again, I just love the fact that I'm able to get this document so I could read through this document, because I tried so hard to explain to everybody, every live that I'm on, I tried to explain over and over and over again what I saw, what I felt, what was read. And so many people say that, Mama Flip, you're wrong. You're wrong, Mama Flip. You read wrong. That's not what they're saying. That's not what he meant. That's not what the judge meant. And the fact is that, Mama Flip, you're wrong anyway, because the jury found him not guilty, right? So that means that, are you saying, Mama Flip, that the jury's got it wrong? Yes, I'm saying that Mama Flip is saying the jury got it wrong. Oh, why would you say that? So all of a sudden now all juries get everything right? That all these people that's been fighting for years to say that they were innocent of a crime, now we're saying that they're all liars? That every jury get it right? Like, come on now. Anyway, I'm glad that I have this documentation that I could read and fall back on, so that you guys could see exactly what's going on. And also, guys, this is like deja vu. I am not going to post these lives because I normally clip up and post these. I'm not. Once these lives are here, I'm going to download it and not post them again. If you want to see what was said on this live, please go to YT. YT would have the whole live, because I can't afford, because unfortunately Tickety Talk is not being fair with none of the content creators, and I can't mess around with them anymore. I'm done. Anyway, let's continue. Combs didn't forfeit or waive these challenges. Okay, so this is the reason why the argument does not hold water, according to Judge Aaron. The first question is whether Combs can bring a legal challenge to his conviction in Rule 29 motion. The government contends that Combs should have made his challenge earlier under Rule 12, and so he forfeited them, and that the instruction given to the jury on the definition of tuition was of his own devising, and so he waived any claim of error. Neither argument persuaded the court. Okay, so said neither argument persuaded the court. Okay, that's interesting. Didn't forfeit or waive the challenges. Okay, let's continue. First, Combs can bring his legal challenges under Rule 29 despite not raising them earlier. Okay, this is good. No, this is bad. This is good for him, but this is bad. These challenges are routinely made and decided by courts in the circuits, including the Second Circuit itself. Okay, so and he cites United States versus Solar, United States versus Denise, United States versus Lopez. I'm not going to read all the stuff. Second, Combs didn't waive his argument concerning the definition. Okay, so neither argument persuaded the court. So you saying that neither one persuaded you. So even though the government said this, you said that it didn't persuade you as far as making your decision. Interesting. Okay, so let's read the second one. Second, so he's saying that Combs Sean lawyers could have made the legal argument and challenge it at any time. The government said that since he didn't challenge it earlier prior to the instruction to the government, to the jury, given to the jury, he shouldn't be able to challenge it now. So the judge is saying that's not true. He can bring a legal challenge anytime, despite not raising them earlier. Okay, so second, Combs didn't waive his argument concerning the definition of tuition by proposing the instruction the court gave. To be sure, this case involved an unusual series of events. Combs proposed instruction, the court adopted it, and now Combs said that it was wrong the whole time. Ordinarily, the invited error doctrine would bar this kind of challenge to the instructions. See United States versus Bosey, United States versus Klein, and that's on appeal. But Combs argued that Rule 29 motion doesn't challenge the jury instruction, but instead turns on what the definition of tuition should be. On that view, the jury instruction aren't relevant to his argument. What the hell? Combs didn't waive his argument concerning the definition of tuition by proposing the instruction the court gave. Combs didn't waive his arguments concerning the definition of tuition. He didn't waive it. Okay, so he didn't waive his argument concerning the definition of tuition by proposing the instruction court gave. So I'm guessing that he could still argue that the definition was wrong, even though he proposed it to the court. Didn't waive. He could still argue it, even though he proposed it. To be sure, this case involved an unusual series of events. Combs proposed instruction, the court adopted it, and now Combs said that it was wrong the whole time. Ordinarily, the invited error doctrine would bar this kind of challenge in the instructions. But Combs argued that the Rule 29 motion doesn't challenge the jury instructions, but instead turns on the definition of tuition should be. On that view, the jury instruction aren't relevant to his argument. Jesus H. Christ. But Combs argued that the Rule 29 doesn't challenge the jury instruction, but instead turns on what the definition is. So I'm guessing he's saying that Combs argues that his rule, that he's not challenging that the jury got the instructions, but that he's just challenging the definition of the word tuition that was in the instructions. On that view, the jury instruction aren't relevant in the argument, meaning that, and this, I'm just a layperson, guys, so I'm just giving it to you as I understand. If you guys understand this completely different from me, then please let me know. But I'm trying to be layman about it. And one of the things I have to tell you, when we were sitting in that court listening to all this legalese that was going on last week, there was several people that was coming out of the court was like, we don't understand what the hell he was saying. And I was like, yo, I think I have at least a basic understanding of what was arguing. I can't talk about every single argument, but I have an overview of what they were trying to do. So I'm guessing. But either way, the judge said that neither of these arguments swayed his decision, which I find to be interesting, because based on the impression I got when he was arguing it, he felt, especially when read earlier, that why, if you gave me the definition to add it to the instruction, why are you now coming back and saying the instruction is wrong? But then even though he's aware that he did that, he said it did not sway him. It didn't hold water. For the arguments don't hold water. So you see what I'm saying? He's saying the argument doesn't hold water, but he said neither argument persuaded the court. So if the argument doesn't hold water, right? These arguments don't hold water. So these argument doesn't hold water, meaning everything that I just said as far as him saying that they gave the wrong doesn't hold water, then how is it that he said it didn't persuade the court? That again is legalese. But either way, he said the lawyers, the defense, could challenge the rule at any time, even if they didn't challenge it before. Okay, I'll accept that, right? Even before, after, during, even before appeal, you could challenge any law. He said that. He said that second didn't waive his argument concerning the definition of tuition prior to the instruction he gave, right? To be sure, this case involved an unusual series of circumstances. Yeah, there's a bunch of stuff. He proposed an instruction, the court adopted, and now Combs said that it was wrong the whole time. And he said that apparently there's an invited error doctrine would bar this kind of challenge. So there's a doctrine that would actually bar this type of challenge, meaning I'm guessing that he wouldn't have been able to even use this type of argument, right? Ordinarily, but he allowed it, right? But Combs argued that the Rule 29 motion, even though it challenged, he's challenging the definition of tuition, he's not challenging the jury instructions. He's just challenging the word that was used in the instruction. And on that view, the jury instruction aren't relevant to his argument, meaning that if you're not challenging the instruction to the jury per se, then you're saying that the jury instructions are not relevant to the argument. You are only arguing the word tuition. The word tuition. Lord have mercy. Combe is right. Okay. Let's get into how is Combe right. And Mensechumi, you could Music Chu. I'm just giving a completely different name. Music Chu, that's MUSACCHIO versus United States. The Supreme Court held that a reviewing court limited determination on sufficiency review does not rest on how the jury was instructed. Okay, 5-7 U.S. blah, blah, blah. Though that's holding address only whether the due process clause requires that an appeal court abide by erroneous jury instruction given below that advantage a defendant. The Second Circuit extended the reason shortly thereafter in the United States versus Blas BLASZCAK, Lazak. It held that this principle has applied when the jury instruction disadvantage a defendant vacated on other grounds. There, like here, the defendant failed to object to the jury instruction, but then challenged the evidence based on a different interpretation under Rule 29. Rely on Massachusetts, the Second Circuit hold that in answering this question, it was not bound the district court jury instruction. Separately from this line of case, the Second Circuit recently gave the same place in United States versus Denise, addressing a Rule 29 challenge, even though it turned on a limiting definition that the defendant didn't insist be included in the jury instruction. The circuit did find the defendant Rule 33 challenge to those instructions forfeited, but Combs isn't making that kind of argument here. These cases support Combs' contention that the actual jury instruction aren't relevant to his Rule 29 challenges, so he isn't barred from now arguing that the Mann Act means something different. So he isn't barred. Jesus H. Christ, what the hell are you saying? These cases support Combs' contention that the actual jury aren't relevant. So we're saying that the jury instructions aren't relevant to his challenge. So he can challenge the Mann Act meaning something different? So he can. So you're saying that he could challenge it. Pretty much, I'm thinking all of this has to do with, first of all, he's saying that Combs is not talking, or his defense is not challenge the actual instructions per se. He's just challenging the word or the definition of the word, right? The court did find that the defendant ruled to a challenge to those instructions forfeited. But Combs isn't making that kind of argument. He will now before Friday. These cases support Combs' contention that the actual jury instructions aren't relevant to his ruling 29, so he isn't barred from now arguing that the Mann Act means something different. Lord have mercy, man. What the hell? Let's continue. Combs' newly proposed definition of tuition is wrong. Okay. Maybe this part will be easier. Combs argued that tuition, properly defined, is two-element absence from this case. Okay. First, the defendant must have a financial motive. Second, the exchange of funds for X must be bilateral. Whoever pays for the X must engage in it. Both arguments share a similar structure. Each pursues that the definition of tuition at the time of the Mann Act passage were overbroad in some respect. Then each suggests a way to narrow that definition to avoid potential constitutional problem. If Combs is right, then his conviction, even on an alternative theory like aiding and abetting, let me make sure I'm not in trouble, should be reversed because no tuition occurred at all. Both arguments fail. Lord, finally a straight answer. I'm sorry, guys, if I'm making this more confusing than it should be. But I'm trying to understand it. I mean, layman, I could read it and say, I could tell you what I felt in the court, what the court meant, layman terms, like a 5-year-old. But I really want to read this court document to see what he actually thought. And it's just complicated to me. But I'm going to continue. Combs got it right the first time. The correct definition of tuition and the Mann Act is X in exchange for money or its equivalent. And that definition poses no constitutional problem. So his definition, I'm guessing from this, that he gave of tuition that was given to the jury, according to the judge, was right all along. Him trying to narrow it now and change it is wrong. That's what I'm getting. The definition posed no, but with that said, the definition of tuition posed no constitutional problem. Okay. Tuition meant X for sales. To any modern reader, the plain meaning of tuition is X for sale. Every modern dictionary, the court consultant said the same thing. C.E.G. tuition, Oxford English Dictionary, the practice or occupation of engaging in actual activities with someone for payment. Tuition, Merriman website, the act or practice of engaging in X acts, and especially actual in exchange for pay. Tuition, Black Law Dictionary, 12 CD 2024, the practice or an instant of engaging in actual activity for money or its equivalents, commercialized X. The Mann Act history doesn't suggest that a different definition applies. Okay, true. In 1917, the Supreme Court indicated that tuition, as used in the statute, could be for hire or without hire. Oh, nice. United States versus Commentators, and there's a bunch of numbers, and that appears to reflect how the words was used at the time. C.E.G. Black Law Dictionary, etc. Definition: tuition as common lewdness and a ordum with a WH. But the court walked away from that expansive definition 3 decades later in Cleveland versus United States, recognizing that tuition normally suggests actual relations for hire. And while Cleveland didn't explicitly overturn Commentators, its definition of tutor was key to the reasoning, LD 1718, reasoning that debauchery defines that tuition is the statute because the botch doesn't require payment. That was the Supreme Court last word on the matter before 1986. So they're saying that tuition, according to the later case, which was upheld by the Supreme Court, doesn't require payment. That's crazy. I didn't know that. I didn't know that. This is good to know. Everybody who does these type of things, y'all better read the Constitution. So let's continue. In 1986, Congress amended the Mann Act, cementing the common sense definition of tuition. It struck the entirety of 2421A and reinserted the tuition clause, but cutting the law's anachronistic features like the botch and immoral right provision, HRP, child. I'm not gonna say any of that. They took away that. Whatever underage and corn. They took away that. Congress is presumed to have been aware of the Cleveland court interpretation of tuition and to have adopted it when reenacting these statutes. So you're saying that they use and reinsert in the tuition clause, but cutting the law when it comes to that, immoral, okay, period. Okay, let me leave it there. They took out debauch and they took moral purposes, right? They took that out. HR Rep 19, when they're talking about now about the underage X in corn Act 1986. So there's this, okay, so we're talking about separate, they didn't remove anything, they talk about a separate case. Congress is presumed to have been aware of Cleveland court interpretation of tuition and to have adopted it when reenacting the statute. Athena Life Insurance Co. versus Big Y Food Inc. That definition is also that in tuition ambiguously meant at the time of amendment an act of actual course and any unlawful actual act for hire. Tuition, Black Law Dictionary, act of performing an actual act for hire. Oxford English, the offering of a body to incriminate lewd for hire. Tuition Webster New Collegiate Dictionary, the act or practice of indulging in promiscuous sexual relationship for funds, especially for funds. To think that Congress instead wanted to invert to Kamita expansive definition of tuition, disregard the entire purpose of the amendment. So he's considering all the amendment that was done initially. Done after the initial Mann Act. So Mann Act was very broad and expansive. So there's been a lot of these amendments. And what Diddy lawyers are trying to do is they're trying to forget all the different amendments and try to stick directly with instead wanted to revert to Congress common special definition disregard if to think it exactly. So they want to say that if that they want to fall back on the original case and pretty much disregard the entire amendment. It eliminated provision that would be criteria as Coma criticized them now for their alarming scope. So now he's criticizing it. There was a dissension. It would make little sense for Congress to get rid of those provisions, but at the same time, preserving a sweeping definition of tuition for the same effect. See Federal Bureau of Prison The amendment is relevant because our construction must, to the extent possible, ensure that the statutory scheme is coherent and consistent. Using the older Communita era meaning of tuition would undo what Congress plainly sought to achieve when it scrapped the debauch and the immoral, provision. Whew. So consistent with tuition ordinary meaning, how the Cleveland court understood it, the judiciary state of play when Congress last amended the provision, and how Congress would have understood the term at the time of amendment. The right definition is the one Combe proposed at trial and that the court used in its jury instruction, engaging in extra activity for money or its equivalent. He did all of that to say that the original meaning of the tuition that was given by Combs' defense defense that was later shared with the jury, even though Combs is saying the Combs defense lawyers are saying it was wrong, is right all along, based on all these changes. And now they're trying to reverse it because they didn't like the fact that he got the Mann Act, but he was right all along. Okay. Oh, Lord have mercy. But Combs isn't satisfied with that definition. Okay. He said that tuition has two additional requirements, neither of which is grounded in the text of the statute. The meaning of tuition at the time of the Mann Act enacted in 1910, or its meaning when the statute was amended in 1986. For the following reason, the courts reject Combs' proposed additional requirement. Defendants need not have a financial motive. Okay, Lord have mercy. Combs first argued that tuition in the Mann Act required that the defendant have a financial motive. There's nothing in the text of the statute to support his requirement. This is a lot easier to understand. And it doesn't make any sense in this context. Combs wasn't convicted of tuition, but rather transporting others for that act of tuition. Combs seemed to be conflating two things: the definition of tuition and the motive of the defendant who transport someone for tuition. The statute requires only the intent the transportation person engage in tuition. Wow. Excellent. 18 USC. Combs' argument imposed an additional mental state requirement for the transporter and grafted it into the word tuition. I love it. This now, can you just make everything else more as clear as this, please, Judge? God dang. A word that by itself doesn't contemplate anyone but the parties involved in the X Act. What happened in this case was transportation for tuition, even under Combs' understanding of the term. Combs transported the Scots who were financially motivated and intended for them to engage in tuition. Whether Combs himself was financially motivated never entered the calculus. There's no basis to adapt Combs' proposed financial motive requirement for defendant in the Mann Act. Lord, guys, I love you. So pretty much the way I understand it is that I always thought, I think I got a little wrong when I said that Combs, I thought that he was trying to say that he did say that since he did not pay for, and I hope he talks about it here, since he did not pay for it, that all he was doing was watching, he wasn't really engaging in tuition, right? But here's another twist. He talks about being financially motivated, meaning that he also did not get paid, because in order to be charged with actually having a harem and doing tuition, the person has to actually get paid. That's what I'm guessing. Have to actually make money off of it. And he said he didn't make money. I thought he was referring, which this is what I got, that they, because he did say that. He said they didn't get money, meaning the guys didn't get money. But he's also saying that he didn't get money also. But the statute doesn't have anything to do whether he or anybody get money. The statute talks about actually transporting people in order to perform this act. And these people was motivated because they knew they were going to be financially compensated. That's why they was motivated. It doesn't mean that he was trying to twist it, and the judge was like, you can't twist it, right? Argues that the Mann Act that the defendant has a financial motive. It doesn't mean that the defendant has a financial motive. It means that you actually transported people in order to engage in that. And these people, meaning the one person, they knew in their mind they were doing it for financial they were financially motivated. So wow. So it's about transporting them for the act. That's what the Mann Act is about, pretty much. There's no, and he was trying to say that I didn't get paid, so why am I being charged? And the judge is saying that's not what it means. Okay, let's go to part 2. This is complicated, guys. The bilateral exchange of money for X is not required. Okay, Combs also argued that tuition is strictly bilateral transaction. One party pays the other. Okay, thank you. This is the part. Okay, I knew that was also part of the argument. One party pays the other for X, then those same two parties have X. That definition would narrow tuition almost out of existence. Yes! It would exclude any situation in which a person pays a third party, like a brothel, to have X with an employee. Thank you. I said it. Remember, I told you that's when he brought it up. To support that narrow construction, and I knew he had a problem with this, to support the narrow construction, Combe invoked a series of state court decisions that he says adapt his definition. Putting aside that none of these decisions interpreted the Mann Act as the government pointed out, these cases are good evidence of the meaning of the word tuition. Lord, he told you that these cases are not good evidence. Lord, he's calling your lawyers a clown. To the extent that the cases are relevant, they stand only for the proposition that states have defined tuition differently within their statutes. Okay. The cases can be grouped into two general, categories. The first group is the Bayesian cases. That's when men do certain things. In each of these a defendant either Bayesian in front of someone else for funds or offered to. Okay, and he has a lot of people versus Green, Commonwealth versus Blythe, State versus Tunbridge, State versus Manfield, and each the defendant was charged with violating the state tuition statute. Each of those statutes defined tuition in a way that the court interpreted to require actual contact between the people involved. Green, citing state law that defined tuition as actual contact between another person in return for a fee, right? Blog, interpretation tuition to exclude self-Bayesian for hire without any physical contact between perform and view, right? Turnberg interpret the phrase non-marital actual courses for anything of value. Manfield interpretation, actual act for hire, where state law defined an actual act or actual corn, fill, Bayesian, or other, and or the causing of pen or any extent of another. Again, if you guys are on YouTube, y'all would be able to see what I'm saying, reading to you guys, because I'm breaking up the word in order to be TikTok-ly and social media friendly. Okay. Combe argued that these cases show that tuition require a bilateral exchange of funds for X. Not so. These cases involve the question of whether these institutions were they no actual contact at all between the participant. That isn't an issue here, given that there was no question that Ventura, Jane, and the S, the male, had X. Exactly. Why are you bringing these cases in which people was trying to define what tuition was based on the acts of these people? Whether you consider a tuition if somebody just watch, whether you would consider tuition if somebody just self gratified. He said it has absolutely nothing to this case because in his case, these people actually had X. So why are you bringing all these other narratives into the conversation where in your case, these people had X? The case says didn't address whether tuition requires a actual bilateral exchange of funds and X between only those participant as Combs insisted. Again, he's saying he can't be charged with this. He can't be charged with tuition because he's not the one that exchanged the money. So he gave the money to Cassie, or he gave the money to Jane. Since they're the one that gave the money, then he shouldn't be held liable for tuition, because that's the only meaning of tuition is when the person who's actually doing the act give the money. That is not true. And even if they were relevant, these cases didn't turn on the bare word tuition, but instead on the definition provided on each statute. Lord have mercy, God. The second group of cases concern strip locations and commercial voyage. A few of these cases simply aren't relevant. One did nothing but note that some form of commercial voyage are distinct from tuition. See Smut versus State. Another, a court held that a dancer didn't engage in tuition with a patron who touched the clothing covering her situation, because Missouri law required touching of a situation themselves. State versus Burgess. But again, recall that Combs' proposed definition of tuition turns on whether the money and the X flowed between the same people, not whether actual touching happened at all. And notably in Burgess, the statute didn't require bilateral exchange of X and money, but covers situation where something of value received by the person or by a third person, emphasized adding, undermining Combs' argument. Meaning something of value could be that he enjoys watching, right? That it makes him happy. It's something of value. The very act of itself is a value to him, or he wouldn't be doing it. It doesn't have to be about him getting funds or money. That's what I'm thinking. Again, you could tell me if I'm wrong. Two other cases in this category appear more relevant at first blush. Okay, give me the cases that's relevant at first blush. In State versus Taylor and Wooten versus Supreme Court, court in Arizona, California confronted the setup of a theater or club where a customer could pay to actually view employees actually touch each other actually, right? In Taylor, the Arizona court held that the charged employee who engaged in such touching with another dancer was legitimately prosecuted under Arizona tuition statute, which requires actual conduct with another person. That was so even though the defendant didn't pay the other dancer, undermining Combs' proposed construction. So they did say that they could prosecute them even though where a customer could pay to watch. Customer could pay. The Arizona court held that a charged employee who engaged in the actual touching was legitimately prosecuted under the tuition law. Okay. Actual conduct, with another person. That was so even though the defendant didn't actually pay the other dancer. Interesting. Undermining proposed construction. So did this fool lawyer just give them a case? Or are you using did you, what? Okay, so either way, the judge had two cases in which he could prove that a person was prosecuted even though they didn't pay. That's pretty much what it is. Wow. And just as Burgess, the Arizona statute made clear that fee arrangement could be with the person engaging in X or any other person. So that case also cuts another Combs argument. So him saying that just because he paid for it and he didn't engage in the X, um, I guess he also used that argument saying that, that because he paid for it and he didn't engage in X, that he's not liable for tuition, but he also said that he's not the one that paid for it. They paid for it, so it couldn't be tuition. He also said that he didn't get anything valuable because he didn't get paid. So he was just, they were using every argument under the sun. Next is in Moonton, the California court held that the purveyor of a similar club weren't involved in tuition. Okay. Unlike Taylor, a combination of the statute definition of tuition and prior case law led to the conclusion that California statutes are not written sufficiently broadly to encompass of actual transaction for a customer who engage only in voyeur. Okay, and they talk about citing Taylor. That the conclusion that Combs would have this court reached that the Mann Act as well. But he doesn't explain why the definition of tuition in a California statute and interpreted by a California state court should control the definition of tuition in a federal statute. Okay, so that makes a little sense. Why are you giving me state laws when this is a federal case? I think that makes some sense to me. The problem is evacuated by the array of definitions used by the statute. Why should one control above all others? Indeed, in Wooten itself, the court observed that the Wisconsin court had adopted a broader interpretation of the state laws that would include statutes where a third party paid for X, such as a businessman paying someone to have X with his client. I talked about that. He said that, demonstrating that these state decisions are statute specific, right? California state contained the language that included in Wisconsin statute that actual conduct alleged herein could constitute tuition. So, okay, so California statute contained the same language. So not every state contained the languages that each other states have when it comes to interpretation tuition. Some people believe it tuition if you touch above clothes. Some people say include tuition if you only touch without clothes. Some people consider tuition if you're watching. Others don't consider tuition if you're not watching. He's saying that multiple states have different definition of tuition, and how is it relevant? And this is what I'm getting to this act. You're giving me all these state cases, but interpreted by the should control, but you never explain. But he doesn't explain why the definition of tuition in a California statute and interpretation by a California state court should control the definition of tuition in a federal statute. So in my opinion, why would California or Wisconsin or anybody statement, why would you pick the most lax tuition definition from a lax state and try to say that it should impact the federal statute? That's what I'm getting out of it, guys. Finally, oh, thank you. Finally, and People versus Paulinho in New York trial court addressed a challenge mounted by a purveyor of X for hire to his conviction for promoting tuition. Lexus is New York, 2005 New York miscellaneous Lexus 3430. The New York law at issue, he argued, should apply also to pornography. And because it wasn't enforced against pornography, his case was selective prosecution in violation of the Equal Protection Clause of the 14th Amendment. The court rejects that argument because it would eradicate the traditional bilateral notion of tuition, which entails paying B for actual activity to perform on A. Wow. At 8, the court isn't persuaded by his interpretation. Polino reasoned that under New York state law, a bilateral exchange of funds for X is required, drawing inference from prior New York City cases and a practice commentary, which itself does not address the bilateral exchange issue directly. It cites no authority for its assertion that this is the traditional definition more generally. Polino instead begins with the premise that pornography simply cannot be covered by the definition and works backwards to explain why. Some of its reasoning rests on the definition it defines from New York authorities, while other parts rest on the premise that a corporation enjoys First Amendment protection while a broth doesn't. That's a lot. Because he wasn't informed against this case was selected prosecution in violation of the Equal Protection Clause of the 14th Amendment. The traditional bilateral notion of tuition, which entails A paying B for actual activity to perform an A. The court isn't persuaded by this interpretation, for the only reason that under New York state law, a bilateral exchange of funds for X is required, drawing inference from prior New York cases and practice commentary, which itself does not address the bilateral exchange issue directly. It cites no authority for its assertion that this is a traditional definition more generally. Polino instead begins with the premise that pornography simply could not be covered by the definition and works backwards to explain why. Some of the reason rests on the definition it defines from the New York authorities, which while other parts rest on the premise that a corporation enjoys First Amendment protection while abroad. So they're saying, wow, this is a mouthful. So when he was talking about it, I thought that he was saying that because he said it. He said that Diddy lawyer says that he is a amateur corn producer. That all these films, the lights, the cameras was created, and the costume was created to do a scenario because he was filming these corns for his own enjoyment, and that is protected under the 14th Amendment. That's what he said in court. And the court is saying that while other parts rest on the premise that a corporation enjoys for while that he was trying to say use this use the citation to say that he shouldn't be charged with tuition because of that. And the judge doesn't agree because it's a state law, one, I believe, and the other, the court isn't persuaded by this interpretation. Pauline reasoned that under New York state law, by bilateral exchange of money for X is required, drawing inference from prior New York cases and practice commentary, which itself does not address the bilateral exchange issue. It cites no authority for its assertion and that it is a traditional definition more generally. He just doesn't agree with that. That he said it didn't cite any traditional. It didn't, I guess it didn't make sense in it. And then also Pauline instead began with the premise that pornography simply could not be covered by the definition and works backward to explain why. So he just doesn't agree with the findings. Some of the reasons rested on the definition as derived from New York. I think he feels it's unreasonable to say that a corporation cannot be charged with tuition if a company pay for tuition for a client, but yet only a brothel can. Sorry, I used the B word. Anyway, let's continue. Defining tuition as X for money doesn't create constitutional problem. Okay. Combs argued that any definition of tuition broader than the one he suggested would create a constitutional problem. Specifically, he said that the statute would be voided for vagueness, violate substantive due process right, create federalism problems, and violate the First Amendment. Even though he makes all these arguments under the aspects of statutory interpretation, he also mounts a standalone challenge to his conviction under the First Amendment. None of these arguments is persuasive. This is a lot, guys. I don't know why I started doing this. A statute is void for vagueness. Fail to provide people of ordinary intelligence a reasonable opportunity to understand what conduct is prohibited. 2. Authorize or even encourages arbitrary and discriminatory enforcement. VP of Berlin LLC versus Town of Berlin, 593. As his counsel confirmed at argument, Combe challenges the Mann Act as applies to him, right? When, as here, the statute is judged on an as implied basis, one which conduct is clearly prescribed by the statute cannot successfully challenge it for vagueness. United States versus Nadi. Combs argued that the act is void for vagueness for 4 reasons. First, because the word tuition had come to mean different things over time. For example, we talked about it earlier, from Seminci in 1917 to Cleveland in 1946. Second, because the statute doesn't include a definition. Third, because the statute have defined it differently over time. And fourth, because the act hasn't been used before for prosecuting someone in position. The court takes each in turn. Why you have to take each in turn, court? Why you have to take each? Just say no. Just no. Okay, so let's continue. This is so complicated. First, the word changing nature has little to do with Combs' challenge. Okay, first, the word changing nature has little to do with Combs' challenge. His argument is that the outer borough of the word meaning has changed. On his account, the definition was previously so broad that it encompassed general lewd divorce from any transaction. And since then, the definition narrows to require the exchange of funds. But neither of these changes has moved his activities in or out of statute orbit. Ambit. I said orbit, but it's ambit. Statute ambit. To be sure, some other defendant in some other case might have a vagueness argument to make, but Combs doesn't show that the Mann Act text doesn't plainly apply to him, where the evidence showed that he transported squats for them to have X for money. So even though there is a lot of vagueness that he's trying to challenge the meaning of the word tuition, because it means different things. It was changed from one meaning to the next, and now different states have different meaning of it. It doesn't help him because it shows by evidence, which is part of the Mann Act, that he actually did transport these guys for them to have X for money. That's the first part. Second, the lack of definition isn't a problem. As the government note, a statutory term is not impermissibly vague simply because it lacks a statutory definition. The United States versus Conception. To be sure, the absence of a statutory definition can be a relevant consideration in the void for vagueness inquiry. But the plain meaning of the statute wording, along with a scienter requirement, can defeat a vagueness challenge. As discussed earlier, the plain meaning of tuition is X for money. Paying a court to have X with someone is exactly the kind of activity that a person of ordinary intelligence would have fair notice is meant by tuition. And on top of that, the Mann Act signed to a requirement also cut against vagueness. A defendant must transport someone knowingly with intent that they engage in tuition. So, and this is what he did. Okay? So him saying the lack of definition is not a problem, because the fact is that it's the and on top of this, the Mann Act does say that clearly a defendant, even though there may be some vagueness, it says it. First of all, he's saying that it was narrow, right? First, it probably was broad, but they narrowed it. With all these amendments, it became more narrow. Okay, and I list some of the amendments that they did before. They took out some stuff, they put some stuff in, right? Go earlier. But as discussed earlier, the plain meaning of tuition is X for funds. Paying an escort to have X with someone is exactly the kind of activity that a person ordinary could understand what tuition is, right? Right, with fair notice. Everybody will know that. But also on top of that, which did happen because someone did pay someone to do those acts. They have receipts. But also the Mann Act is very simple. It talks about knowingly and with intent to travel, to send somebody, to transport, to send them on a trip in order to do this type of action. That was clearly shown in this case. So that's what he's saying to me, right? So also, so he lists that. Third, the state law definition that Combs raises aren't relevant. Though the Mann Act has a provision that integrates state laws, that isn't the one that Combs was convicted under. Why can't you just say that earlier? Save me all this reading. And I think that's what I said earlier. I said that I believe that he's saying that all the state laws that he threw at him has nothing to do with his case, because he was convicted under federal statute in the federal court. If Combs' argument is that the constellation of conflicting state law rendered the federal term vague, this presents two further problems. The first is that, as has been already discussed at length, yes, at length, thank you, the state law cases that Combs cite don't conflict with the definition the court used. Even if they did, which they don't, they interpreted statute with different languages. The second is that even if there was a conflict, the court is skeptical that a federal statute could be defringed by state law that occupy a similar field. The principle of presumption in intergovernmental immunity runs in this other direction. Okay. Wow. So if you can't, I'm guessing if you can't charge somebody for both the state and federal, then you can't use the state laws to interfere with a federal case. This is how I'm reading this, which is the presumption into intergovernmental immunity runs in the other direction. If you're immune from being charged for a state crime that is the same as a federal crime, then it should also be the case that court is immune from considering state laws in their federal cases. I'm guessing that's what he's trying to say. Fourth, it makes no difference that this statute may not have been applied this way before by the government. Combs argued that he, the only person ever convicted. Yes, they've been using that argument the entire time. Everybody used that argument. Oh, it's not fair because the Mann Act was meant to be used for something else. Oh, they're going after the powerful black man. They're going after him. They're using the Mann Act to bring down the power of man. It's not right. Let's see what the judge says. Combs argued that he's the only person ever convicted under the Mann Act for his conduct. Dr. 48612. He cites Department of Justice guidance against charging tuition customers under the Mann Act. So I guess he's a customer, not a purveyor. But criminal laws are for courts, not for the government to construe. Wow. Okay. Abraham versus the United States. and that facts that defendant is the first person to be prosecuted under a provision for a specific conduct does not render provision vague. They always have to be a first. They always have to be a first. So you're the first one. Then they're going to use it for others. Thank you for being the first. United States versus Harman. See also United States versus Albridge, right? And then name it. That especially true, whereas here the defendant conduct fits squarely into the statute text. Yep, you did that. Substantive due process. Okay. Combe failed to show that his convictions implicates any rights or liberty interests protected by the Fifth Amendment. He argues that law-bending tuitions are hard to square, which Supreme Court decision recognizes substantive due process right related to actual activity. In doing so, he leans on two cases that are in opposites. First, he cites Abufield versus Hogg, which concern only the rights to marriage, not any specific right to participate in actual activity. I think his lawyers are insane. This is and some of this thing is embarrassing. His lawyer, like I said, his lawyers are throwing everything against the wall, even stuff that doesn't really apply. Second, he leans more heavily on Lawrence versus Texas, which did concern actual activities, but as the government points out, the Lawrence court explicitly wrote that it wasn't addressing tuition. Why would you bring cases that doesn't address your case? The case does not involve tuition. It says it clearly in the case. Combs' argument is carbon to subjective inferential support from authority like this. He doesn't invoke the Glicksberg test, provide any careful description of the asserted fundamental liberty interests, or explain why the right to pay someone for X is explicit in the concept of order liberty, such that neither liberty nor justice would exist if they were sacrificed. Washington versus Glicksberg, a citation in Turner. Sometimes I think that the judge is giving him laws and rules so that he could appeal. Because what the hell? He doesn't invoke the Glickson test, provide any careful description of the asserted fundamental liberty interest, or explain why the right to pay someone for X is explicit in the concept of ordered liberty, such as that neither liberty nor justice would exist if they were sacrificed. I'm guessing he's saying that, which is a lot of people saying that tuition should not be illegal. That's what I'm guessing. He said that he didn't even try to argue that tuition should not be illegal. He's just saying that he shouldn't be charged with it. So he did say he argues that law banning tuition are hard to square with Supreme Court decision regarding substance due process right related to actual activity. In doing so, he leans on two cases, which is opposite, right? One has to do with the right to marriage, but I'm guessing he's talking about same sex LGBTQ. I'm guessing, right? Second, the right to marriage. A second leans more heavily on Lawrence of Texas, which did concern actual activity, but as the government pointed out, the Lawrence court explicitly wrote that this wasn't addressing tuition. So if it wasn't addressing tuition and you are being charged with actually transporting people for tuition for X in the broader text, why would you use this? Why would you bring it? Why would you bring this case? Right? Combs' argument is combined to suggest inferred support for authorities like these. He doesn't invoke, and this is why I say that he's giving him too much information. So what if he come back and invoke that? Then now we have to do this again? Shit. Federalism. Combs relies on Simonelli versus United States for the process of proposition that the scope of federal statute should be narrowed when it governs a vast array of conduct traditionally policed by the state, right? Quoting Cleveland versus United States, because the state regulate tuition, he said, the word tuition should be read as narrowly, it's 12, 13, okay, as narrowly as possible. This argument misapplies the fundamentalism canon. The canon, as deployed versus similarity and elsewhere, requires Congress to convey its purpose clearly before it deems to have significant change the federal state balance in the prosecution of crime. Sorry, tickety talk. Cleveland. That met here. The statute criminalized the interstate transport of people for tuition. A concern could hardly be traditionally policed by the state. So the statute does say that. So, okay. Camellia Accord Western Union Telegram Company versus Cal Pub Co. This court has often held that the full control over interstate commerce is vested in Congress and that it cannot be regulated by the states. Moreover, even if tuition was traditionally regulated by state, Congress' intention to criminalize activity related to tuition is crystal clear from its use of the word tuition in the statute. There is no ambiguity there. He relies on Similarly versus United States for the proposition that the scope of the federal statute should be narrow when it governs a vast array of conduct traditionally policed by state. So he's saying that the federal government statute should be more narrow. Should be narrowed because a lot of these laws are governed by the states. Because the states regulate tuition, he says the word tuition should be read as narrowly as possible. The argument misapplied the fundamentalism canon. The canon, as deployed in Sandinelli and elsewhere, requires Congress to convey its purpose clearly. So the Congress shouldn't narrow. The Congress makes sure that its purpose, they told its purpose clearly before it's deemed to have significantly changed the federal state balance in the prosecution of crimes. So the statute criminalized the interstate transfer of people for tuition, a concern that could hardly be traditionally policed by the state. So so tuition and transfer is a crime. So it cannot be policed or changed by the state. The court has often held the full control over the interstate commerce is vested with Congress, meaning the interstate, whether it's federal. So Congress has control of that part, and it cannot be regulated, meaning the Congress, meaning federal, have a say or have full control when it's defining interstate commerce. So you can't all of a sudden say the state, because the state rules differently with tuition, that the state has control. Moreover, even if tuition were traditionally regulated by state, Congress' intention to criminalize activity related to tuition is crystal clear. So even if one state says that tuition is legal, overall the federal government still holds that is illegal. So there's no ambiguity there. Okay, we go into the First Amendment. My God, man, that's why I was there for an hour and a half. Combs argued that because he's an amateur, here it is. Thank you. This is the part that actually took me out. Combs argues that because he's an amateur pornography and consumer of pornography, his conviction violates his First Amendment rights. Thank you. All right, let's read this BS. Because I shook my head on this one. I'm like, oh, so now he's doing films. First, Combs. Okay. Conduct is not protected by the First Amendment. Thank you, Judge, for making that clear. First Amendment protection applies only to conduct that is inherently expressive. Remsley versus F for ACAD and RTS Inc., whatever. Conduct is inherently expressive if they are both an intent to convey a particularized message, and the likelihood was great that the message would be understood by those who viewed it. Lord. Texas versus Johnson. Okay. 491 US 397 407. Okay. Citation quotes. Okay. Through film, though film is an expressive medium protected by the First Amendment, at some point it must certainly be true that otherwise illegal conduct is not made legal by being filmed. Thank you. California versus Freeman. Also see Remfield. If combining speech and conduct were enough to create expressive conduct, a regulated party could always transform conduct into speech simply by talking about it. Interesting. And the same goes for the desire to view pornography performance. At some point, illegal activity can't be laundered into constitutional protective activity just by the desire to watch it. Wow. Combs' conduct goes far beyond that point. Evidence at trial showed that when Combs filmed, he didn't typically give notice ahead of time or ask for consent, as a film producer would. Oh, Judge, that's beautiful. I was when he said that he was a pornography. I said that's BS. I just called BS. I rolled my eyes time. I said this man about talking some crap. But I love the way that he put it down in law. Like, you didn't get assigned consent. You didn't tell them that it was for that purpose, right? You can't just say that an act that you've done illegal is suddenly legal by just changing the definition and saying that it's pornography. That's beautiful, Judge. Thank you. Okay. Also, he says the evidence of trial show that when Combs filmed, he didn't typically give notice ahead of time, ask for consent, and as a film producer would, and that he suggested that the purpose was his immediate actual gratification. This man is a fool. The fact that he used this case, no notice or consent in film, 488, same, 560. Wow. So he said no notice is said. He said 418 same, 565 Bayesian. Oh my God. In fact, he sometimes participated in the act. Wow. The evidence shown that Combs and the escort were both have, yes. Oh my God. You're right. You forgot about that because they kept on saying that. Oh my God. He's absolutely right. The evidence did show that because he kept on saying he did not have X with the escorts, but they both participated together to have X with Cassie at the same time. So that's the same thing. Yes, Judge. Of course that makes sense. I just thought on surface it was bullshit. But if you go into the details of it, obviously. And after Ventura and Jen finished having X with Scott, Combs would have X with Ventura and Jane. Often while the escort, oh my God, the situation was still on their situation, on their body. The men's situation was on their situation. At other times, Ventura would put the men situation while usually on his chest, or oh my God, Judge, you had to write it out again. We heard it in court. Judge had to write it out. So either way, it shows that he participated. And I even said that. I said, how is it? I didn't say it to you guys, but I said, how is it? That part I said, that's part I said clearly. I said, how is it that you went in and had, I forgot about the part where he had X with these women, also with the guy. I forgot about that part. I said to that how is it that after that happened, you actually went inside with the women and took the men's situation and spread it all around you. How is that not you participating in the act? They were trying to explain, oh, because that's that was his girlfriend, so he was just having regular sex with his girlfriend. I'm like, that doesn't make sense. So I definitely said that, and the judge put it there. Thank you, God. The judge could write it out a lot clearer. Me, I'm just basic 1, 2, 3 ABC. Like, this sound about some BS to me. So Combe incidentally filming resembled the fact of Alkea versus Claude Book Inc., in which a bookstore could be shut down to combat the tuition happening on its premises. Okay. Oh, it says in the fact, even though the restriction affected the distribution of pornography materials, the shutdown didn't explicitly implicates the First Amendment. Okay, the shutdown didn't, even though the restriction affected the distribution of pornography, the shutdown didn't implicate the First Amendment. The court underscored the fallacy of seeking to use the First Amendment as a clause for obviously unlawful sexual conduct by diffamous devices of attributing protected expression attributed to that conduct. Go ahead, Judge. That's crazy. That's a mouthful. That's a mouthful, Judge. And a concurrence, Justice O'Connor emphasized that any other conclusion would lead to the absurd result that any government action that had some conceivable speech inhibiting consequences, such as an arrest of a newscaster for a traffic violation, would require analysis under the First Amendment. Okay, I hear you. So the person can't say, oh, it's because I was reporting on a case. You can't arrest me for a traffic violation. I would try that, though. So, I'm just saying. Against that, Combe relies on 3 states' court cases. None moved the needle. First, in the Pauline case in New York, discussed earlier. Thank you. You discussed it several times. Yes, the Pauline court worried about the consequences of extending tuition law to commercial pornography, Pauline 2005. But Combe didn't engage in anything resembling the adult film distribution that Pauline assumed would be filled by the First Amendment. Recall that Combe doesn't bring facial challenge, but instead only challenge the statute as applied to him. That means that just as Pauline confronted a factual situation far from the core of any protected activity, so too does this court. The other two cases where tuition convictions were invalidated based at least in part of free speech constitution, People versus Freeman. Yeah, that's the California State Court case that held that the California statute on tuition would violate the First Amendment if applied to pornography, and State versus Therriault, Therriault, a New Hampshire Supreme Court case involving a defendant who paid to video X between 2 people, but in both cases, the court free speech concern aroused from the fact that the defendant purposed for the film a performance, not actual rouse or graph. That isn't the case here. See Foreman. There is no evidence that the defendant paid the acting fee for the purpose of actual arouse or graph his own or the actor. Defendant, of course, did not himself participate in any of the actual conduct. The act of alleged tuition in this case were not crime independent of, apart from payment for the right to photograph the performance. There was no evidence or allegation that the defendant acted with the purpose of actual arouse or graph, and that's not the case with this guy. Second, because he did all of this in order to be aroused, Second, even if Combe conduct falls under the First Amendment protection, his conviction doesn't violate it. If speech is implicated, then the Mann Act is a content-neutral restriction that has an incidental effect on speech. Such restrictions are analyzed under O'Brien test, United States versus O'Brien, City of Error versus PAP, AM. The O'Brien test is satisfied if 1, the government has the power to enact the law; 2, it furthers an important and substantial government interest; 3, the interest is unrelated to the suppression of expression; and 4, the restriction is no greater than essential to further the government interests. Combe challenged only the second prong, whether the law furthers an important or substantial government interest. On the outset, the government has a strong interest in controlling tuition within the jurisdiction. Fine. Freeman, 488 U.S. Connor, J. and Chambers. Also, Kilgoy versus City of South El Monte. There is no question that curtailing tuition is a substantial government interest. Yes, I remember the court and the government saying that tuition include a lot of bad things happening to the people that's being hired, especially the women that's being hired. So the government has a very much an interest in controlling tuitions because it creates a lot of bigger, broader problems. So I remember that. Pauline, 2005, 14. Tuition carries with it a host of ill, including various diseases, rugs, also imping, loan, pow pow with the hands, and also grape. Add that to the significant federal interest in halting the interstate X trade, which may be associated with all manner of other criminal conduct. Contrary to Combs' assertion, his own activities implicated many of those concerned. While paying for X, he enabled commercial tuition, distribution of illegal rugs, and physical pow pow. And again, this is why he was trying to get everything thrown out, because he's saying that it's not fair to use the fact that all the other cases that he was found not guilty, those specific cases addressed and showed all these acts. They showed the tuition, they showed the rugs, they showed the physical, they showed all of this. So he's saying that the judge should forget all of that and throw away the case because he was found not guilty of the charges. To me, that's crazy. Against that, Combs argued that the government pro-offer interest in controlling tuition is not implicated in this unprecedented case because there were no underage involved. Right? He asserts that the legislative history around the 1986 amendment of the Mann Act made clear that the statute was not intended to apply to transportation of fully consenting adult males. That's what he said, right? His evidence consists entirely on a citation to the title of the act that include the amendment. I can't say anything on. The House report summarizing the purpose. That the title and legislative history focus on underage is unsurprising when one of the act's primary function was to create a new underage coronary crime. But at the same time, Congress amended in a way that obviously included more than just conduct involving underage, right? Criminalizing transport for any actual activity for which any person can be charged with a criminal offense. It says that clearly. It doesn't just concentrate on underage. It talks about any act, any person. And looking at the rest of the text, it plainly isn't limited to underage, who specifically addressed in different section. Compare whoever knowingly transport any individual. It doesn't say Also, with 18 USC, a person who knowingly transfer an individual who has not attained the age of 8, underage, the 1 in 8 years. Okay. Finally, so whoever knowingly transfer any individual, also a person who, it says, okay, with a person, whoever knowingly transferred any individual with, so I guess it's not only but with. So even though they did add under 1 and 8, is not, they're not talking, the Mann Act doesn't only talk about traveler, it says with. It also finds the individual who is actually traveling, who could be of any age, any individual, any age. As far as transporting, that is the key here. Oh, it's a lot, guys. It's a lot. Finally, though Combe doesn't mention the fourth prong, O'Brien, the court notes that the Mann Act isn't broader than necessary. The requirement of narrowing tailoring is satisfied as long as the regulation promote a substantial governmental interest that would be achieved less effectively absent the regulation, and the means chosen are not substantially broader than necessary to achieve that interest. Wood versus Rock, against racism. Sorry, guys. Ward, WARD. Ward versus Rock against racism, 491, 1989. The first requirement is clearly met here, as the law works to curb the X trade. And the second is also met because the law applies specifically to interstate transport, not more broadly to the X for hire itself. Again, the Mann Act is talking about the transport. He keeps trying to stick to the tuition and the definition of tuition, and the fact that different states have different definition, and that the government shouldn't take up a fight against tuition, and that he's the first one that actually had this, he's the first one and the only one that actually was brought up on these charges to get this case thrown away, and the judge is saying no. All right, so he did say Combs is right about something. Let's see what he says Combs is right about. Freaking, this is another 10 pages. No, another 3 pages. We're almost done, guys. Combs is right that the Mann Act text and application has changed over the last century, but that has little relevance to his conduct, which sits in the heartland of the Act legitimate prescription. Unsurprisingly, unsurprisingly, then his convictions raise no constitutional problems. There are sufficient evidence to convict under the definition adopted. Okay. Tell me what these are. Combe, fact-based challenge also fails. He argues that the evidence was sufficient to convict him under the definition of tuition used at trial. To sustain the conviction under the Mann Act, one of the dominant purposes of the transportation must be the transport individual to engage in tuition. United States versus Miller. Okay. It needs not have been his only purpose or motivation, but it must have been more than merely incidental. 1 point. Combs argued all sounds in the same tender, that even if he paid, okay, so he did agree, even though he said he didn't pay, he said the ladies' day, but it does say that he argued also, right? Even if he paid escort, they had X with Ventura and Jane. He didn't intend to pay for X at the time of the interstate travel. Oh, interesting. So you just brought them there to have X, but you didn't intend for them to have X when you paid, or didn't intend to pay for X at the time of the interstate travel. They're citing United States versus Buxmeyer 616. Instead, he meant to pay only for their time. If they ended up having X on that time, or even if it was foreseeable, it wasn't the object of the transaction. So here, he has said that he did pay for X with these escorts, right? So even if he did, it wasn't intended to be paid for to have the X. If it happened, it happened, but it wasn't his intent. He only meant to pay for their time to come and just sit down and watch him and stare at his face and talk to him. And if they so happened to have X at that time, it wasn't planned. It was just something that happened. He didn't plan it that way. That wasn't the intent. To support that framing, Combe argues that the evidence at trial shows that the X was never part of the bargain. He points to evidence that the agencies that provided the escorts didn't advertise themselves as selling X for funds. Instead, they offer time and companionship, or alternatively dancing and taking unclothing services, but not X. During the negotiation, Combs wasn't privy to any of the details other than what we're doing and who available. So he used the fact, this is where he tried to use the women again. So he said that he wasn't told that he wasn't told the details. He just wanted to know in his text, so what we're doing and who's available, right? So he's saying that by him saying that, it could mean anything. It didn't necessarily mean that he wanted to have X with these people, right? We should assume that he just knew that they were coming just to do some shows or some dance. And if he did pay for them, which he did, and the ladies did, but if he did do it, it was only for time and companionship, not for anything else. He was doing it for that, and he didn't know because he's not the one that had the conversations. He was just there. Okay, so here we go. One of the escorts wouldn't have thought twice to think that it was tuition, right? This is true. One of the escorts was like, okay, it is what it is. I'm about to get paid a lot of money. Why not? Another who massaged Ventura was there only to create what he called a sexy scene. So he's using that, right? At least one of the escort also had X with Ventura without payment and felt romantically attached to her. Apparently that's Dave. Or maybe it's not Dave. Maybe it's the other guy. Because Dave is crazy. Finally, Jane and Ventura sometimes describe the escorts as entertainment, paid to entertain. So as a result of all of that, they want to pull everything out because they said it in their texts, they said it in the messages, they said it. So because they all said these various words, and he never specifically said, which is not true because he did specifically ask in some of his texts, what are you doing? Jane is coming to town. You need to talk to her and get her to come down here. He definitely was very detailed in his plan to get Jane down here to have extra activities with the trainer. So he definitely said it. But his lawyer argument is because there wasn't specifically purchased, right? Because he didn't say it specifically to them. The ladies may, but he didn't. That he was only paying for just a show. That there's no way that these also would think that he was just only using them for that. If it happened, it happened. And because at the end of the day, there was at least one time when Cassie allegedly had at least X with someone without payment, and the person felt romantically involved with her, that doesn't mean anything went wrong. That's what he's saying. The problem for Combs that the court deferred to the jury choice of the competing inference that can be drawn from the evidence. United States versus Grifton, United States versus Morrison, and a great deal of evidence supporting the competing inference that a dominant purpose of the transport was to pay for X. First, evidence at trial showed that both parties to the transaction as if they were engaging in tuition. Each side worried that the other side was undercover police. I just love when he used specific language. Again, this is what makes them so pissed off because they're like, oh, you're using You're using statements from the charges that were dropped. That's not fair. But that's not true. It all falls in line to why you did the transporting, and that is part of the Mann Act. East side word that the other side was undercover police, a concern that wouldn't be relevant if Combe intent hasn't been to pay for X. At least one escort asked Combs whether he was a cop, and Combs had Ventura ask multiple escort the same. You see? Right? GX 3811. Hey, are you a cop? Ventura, Sean wanted me to clarify if the person was a cop. And Combs believed that the escorts were frequently being tested for actual transmitted situation as part of their job. Jay, he just said, why wear a rub? These guys are safe. They get tested all the time. That's what she said. Second, Ventura testified that the courts were paid to release their situation and to have X with her, contrary to Combs' contention that they were paid for their time in combination. Exactly. Again, I told you he believes the women. For the escorts who were interacted with, what are they paid? Thousands of dollars to do A, to jack Q, to finish. Okay, he's using a lot of the testimonies, boy. For all the dancers you interacted with, what were they paid to do? A, to entertain and to also ultimately have enter with me. Even the sport that Combs claimed testified that he wouldn't have thought twice to think it was tuition, explicitly said that he was paid money for X and wasn't paid when he couldn't actually perform. Good, Judge. Good. I think he's talking about the Punisher. A lot of these guys came in trying to the escorts, whatever that DJ, whatever his name is, I forgot his name, he gets on my nerve. And all the assistants, all the men came in. Most of the men, not all of them. The hairdresser, he didn't come in doing that, but most of the men came in trying to protect Diddy. They're trying to protect Diddy, but what happened is that in you trying to protect Diddy, you still had to tell the story. And in telling the story, you still told us exactly what it was. So even though you said that, you still knew that you were being paid to do certain things. And you also knew that if you didn't, because when it came to Punisher, that pissed me off, because Punisher was one, and I like Punisher, but he tried to imply, I don't think he was really specific in saying that none of them, I don't think any of them really said that they were tuitions. They tried to say that, oh, it was a lot of performance and stuff like that. It was a lot of dancing. Later on it became a financial thing. But what he fails to understand, and the judge is taking into consideration, is that they got paid when they performed. If they did not perform, they wasn't paid or they were paid less money. That's what they said. So if you weren't supposed to be paid to perform and it wasn't tuition, then that means that if you don't perform, whether you perform or don't perform, wouldn't have mattered. And I think that's what the judge is saying here. Even the escort that Combe claimed testified that he wouldn't have thought twice to think it was tuition, explicitly stated that he was paid money for X and wasn't paid when he couldn't perform. Exactly. That's tuition. Thank you. What did Cassie Ventura give you money for in around 2016? Another one say to have X with her. Exactly. They keep trying to rewrite history, but it's clearly said. Jay testified that multiple men was routinely paid by Sean after they finished having X with her. Exactly. Third, their compensation was teetered to their performance at the job. Thank you. When escort jacked without having been told to do so, Combe wasn't pleased by their performance, and they would take less funds. Lord have mercy. And fourth, even though some escorts also spent time with Ventura and Combs outside of sexual activity, and he's talking about the trainer, other engaged in sexual activity on every single trip with both Ventura and Jane. Every time we meet with Miss Ventura and Mr. Combs, what was the purpose of the meeting? To have X with Cass? Jane, and typical hotel night, how many courses with entertainment, and with them finishing, I'm sorry for saying that, at the end of each hotel night with Cabril, it was Cabril, yeah, Cabril is the trainer, I believe. What, if anything, did you give to Cabril? A, funds, right? Combs' other argument falls flat. Yes, much of this evidence comes from other sports traveled, right? But it's still relevant and probative of Combe intent beforehand. United States versus Gopher. Subsequent acts are frequently probative as to intent. And to be sure, some of the squats may have had mixed motive, as Combe pointed out, but the evidence still support that Combs intended to finance the squats for X, and that the squats indeed had X and got financed. Finally, even if the government relied on some circumstantial evidence, it's also present direct evidence in the form of Ventura and Jane testimony. In any events, jury verdicts may be based entirely on circumstantial evidence. That's right, Judge. That's right. Even though I think the jury got it wrong with the other three cases, that's right. At least we got two. At least we got two. United States versus Retaliation, quoting Gopher. There are also sufficient evidence amid a trial of interstate transport of squats of Ventura and of Jane. And I always say that they want to keep talking about Jane and Cassie, but they also keep failing to talk about the fact that he squatted, he traveled the squats, the men, for paid X. They keep talking about, oh, he went on vacation with his girlfriend. That's his girlfriend. That's his personal business. But they keep trying to forget the fact that he actually brought these males across to do these things, right? For this reason, Combs' argument that the squats who testified at trial didn't themselves travel between states isn't ground for granted relief. By the way, they did travel between states. Anyway, no new trial is warranted until under Rule 33. We're almost done. Oh my God, this is crazy. Oh my God, this is crazy. This is long. This shit is long. All right, this is the last page. Oh, Combs said that he should get a new trial under Rule 33 because of the reek and the X traveling shouldn't have been joined together under the Mann Act counts. Okay, this is interesting. I'm interested and see what he has to say about that. The evidence introduced to prove the former, he said, spilled over and prejudiced the jury against him on the latter. I thought, anyway, again, he was happy that the jury did not charge him with the 3, so I guess, anyway. See United States versus Hamilton discussing retroactive misjoiner. These challenges are difficult to prevail on. On a general matter, a Rule 33 motion should be granted only with great caution in the most extraordinary circumstances, such as 969. And on top of that, a defendant arguing prejudicial spillover bears an extremely heavy burden. Grifton. A court considers whether the evidence that related to a dismissed charge was of a type that can excite or arouse the jury into convicting the defendant. The similarity and differences between the evidence relating to the dismissed charges and the evidence related to the remaining charges, and the strength of the government case on the remaining counts. The government argued that these factors shouldn't come into play, and that Combs' argument should be summarily rejected. Summarily rejected, because that no precedent for a new trial based on retroactive misjoiner following a split jury verdict. Putting aside whether that's correct, Combs disagreed. It's certainly correct that Combs is asking the court to find retroactively Ms. Joyner in unusual circumstances. He said that the evidence that was introduced on the REEC and ex traveling charge prejudice him prejudice 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 him on the Mann Act counts. I'm exhausted. I'm sure I'm saying the word wrong, but he was acquitted on the Rick and the ex traveling count. So his claim is that the jury was prejudiced against him because of the evidence of the rack and the ex traveling, but still didn't he him guiltily of those same counts. What? I think there's something going on with that wording. So he claimed is that the jury was prejudiced against him because I think I said the word right, because of the evidence of the rack and the ex traveling, but still didn't he him guilty of those same counts. As Combs conceded, the Second Circuit has never found spillover prejudice when the jury acquitted the defendant on alleged prejudicial charges, and for that good reason, the absence of such spillover is most readily inferable where the jury had convicted a defendant of some charges but not on others. Hamilton, when the jury was able to distinguish between counts, or better, or between defendant, and to assess separately the evidence pertaining to each, no basis for concluding that a new trial is warranted. As a result, the typical articulation of retroactive misjoinder is that it kicks in only after later developments, such as a district court dismissal of some counts for lack of evidence, or an appellate court reversal of less than all conviction rendered the joinder improper. Quoted United States versus Jones. Neither of these scenarios ponder a split verdict. So you're saying the cases that he talks about doesn't address split verdict. That these factors should come to play, and that Combs' argument should be summarily rejected because there's no precedent for a new trial because a retroactive rejoinder following a split jury. There's no precedent. Okay. So there's no precedent. So, okay, it's certainly correct that Combs is asking the court to find retroactive. It is in unusual circumstances. So him coming up with this argument is unusual. Everything he did is unusual. Everything in the defense lawyer is unusual. He said the evidence that was introduced in the RICO was spillage and stuff like that. It's like a spillage. So he claimed that the jury was prejudiced against him. Oh, I got it right again. Because the evidence of the rack and stuff, but he still didn't find him guilty. I think the word find him guilty of some charges. He forgot the word charge. As Combs could see, the Secretary never found spillage prejudice when the jury acquitted the defendant on alleged prejudice charges. That's for good reason. The absence of such spillage is most readily inferable where the court has convicted the defendant of some counts and not others. When the jury was able to distinguish between counts and between defendant and to assess separately the evidence pertaining to each basis for concluding that a new count warranted. As a result, the typical articulation of retroactive misjoinder is that it kicks in only after later development. Okay, so after pretty much later development, if somebody was found innocent of something, right? Dismissal of some of the counts for lack of evidence, okay, or the appellate court reversal. So that's the only time. Okay. Neither of these scenario ponders a split verdicts. Nevertheless, the court declines to summarily reject Combs' argument without reaching reaching the test. Applying the relevant factors, Combs failed to carry his heavy burden of showing spillover prejudice. So he wasn't able to prove that it was spillover. The court takes the factor in reverse order, stating that the third, the strength of the government case. Yes. As described earlier, the court takes the factor in reverse order, stating that the third, the strength of the government case. As described earlier, the government at trial presented overwhelmingly evidence. I love this. Listen this. Listen with this. Listen with it. The court takes the factor and takes the factor in reverse order. This judge take the factor in reverse order, stating that the third, the strength of the government case, as described earlier, the government at trial presenting overwhelming evidence of Combs' guilt under the Mann Act on many occasions with respect to both Ventura and Jane. That evidence consistent with testimony from Ventura and Jane, testimony from the Scots involved, evidence from texts and emails, also don't forget receipts, the government also provided in case many times over. That by itself might be enough to dispose of Combs' challenges, but the other factors don't do much to help Combs either. He conceded that under the second factor, if the inflammatory evidence would have been admissible anyway on a separate trial from the remaining counts, then his claim of spillage over prejudice likely failed. I don't know what I mean. Docket 486 at 59. That narrows any factual challenges to evidence unrelated to Mann Act charges like the fire and the force work, to give a few examples. But on the first factor, it isn't at all clear that this evidence worked to incite the jury or prejudice Combs. It weighs heavily that the jury declined to convict him on any of the counts related to that conduct. Had the prejudice indeed been so great, one would expect a jury to convict on the most relevant counts before it could spill over, and in fact the others. A new trial is not warranted. God, this is crazy. I love this part. Had the prejudice indeed been so great, one would expect a jury to convict on the most relevant counts. I love this statement. I wonder if that statement proved what I've said alone, that the judge believed that the jury got it wrong. But he's saying, because in my opinion, he's saying, had the prejudice indeed been so great, one would expect the jury to convict on the most relevant count. It's the word most relevant counts that gets me. Is the word most relevant counts. He believed those counts was very relevant. I could be just reading too much into it, but woosah. Go ahead, Judge. Conclusion. For those reasons, Combs motion Rule 29 and 33 is denied. The clerk of court is directed to terminate that for 85 ordered. Oh, girl, Judge, wow, that was a lot to read. Oh my God, that was a lot. That was a lot. That was a lot. That was a lot. That was a lot, guys. Oh my God. Oh, Judge. I can't wait. So either way, the court is, the case is this Friday, and I can't wait for the case to be over, because I want to be able to just go through this rest of this trial and just move forward. To be honest with you, I want to be able to go through the rest of the trial and just move forward. So let's stop. All right, guys. It's exhausting, but I do want to read some of the Cassie's letters, some of the letters with the judge. Wow, that was powerful. I think, again, it's difficult to read. It's difficult to read like court cases and legalese, especially if you're a lawyer, especially when you read all these cases and stuff like that, and especially the various nuances in it. But I hope that I had a basic understanding of what he he said. I hope I did. I'm gonna watch other content creators to see, because I read this directly from you guys. I didn't watch anybody else interpretation of what he said. I just took out, being in that courtroom, I just took what he said and made it my own interpretation. Said, okay, even though they're using a lot of legalese language, I'm like, okay, this sound that he means this, and this sound like he means that. I think based on what I read, my conclusions was correct. There were some situations where I felt that he was giving the defense too much instructions to say, okay, you didn't get through with this, then maybe you should have fought this argument or made this argument. I didn't like that because they could come back with it. But I think clearly he said that the evidence was there. The evidence was there. It was very relevant. All the evidence was relevant. I seriously think that he believed that the jury got it wrong, right? Because I think that he said that all the evidence, everything he sees, is relevant to this case. You know, I think that he thinks that Diddy was very lucky. You know, again, that's just my opinion. Okay, so anyway, several of the survivors wrote letters. I don't think Jane wrote any letter, but Cassie did. So we're gonna read Cassie letter. As the other day, I read the letters for him, character letters for him, for people who've known him for many years and stuff like that. I wonder if his god brother wrote a letter. I have to find out because I didn't read that one. So I just read the person that I know, because I know one of them personally that wrote the letter. I read it, and I also read um, Young Miami, and I read um, Robert De Niro, daughter-in-law, former daughter-in-law letter, and stuff like that. And I think I read Stevie J's letter. But let's see what because I know a lot of people read it already. I'm sure they did. I just want to read what Cassie wrote clearly, and there's a couple of other letters I want to read, but I'm particularly interested in what Cassie wrote. Again, you probably all heard it already through the courts, through the media, but I want to read it here. Dear Judge, I think she said his last name. I have been in a cycle of thoughts and then over thoughts writing this letter to you. If there is one thing I have learned about this experience, it is that victims and survivors will never be safe. Although I can hope for justice and accountability, I have come to not trust anything. I hope that your decision considered the truth at hand that the jury failed to see. Thank you, Cassie. Thank you for saying that. Thank you for saying that. They failed to see it. They didn't care about the women. For 4 days in May, while 9 months pregnant with my son, I testified in front of a packed courthouse about the most traumatic and horrifying chapter in my life. I testified that from age 19, Sean Combs used. All right, guys, I am going to. Hey, guys, I gotta. Okay, guys, if you guys want to see it, you guys have to. Oh, I didn't open it up. Oh, I'm sorry, guys. Give me 1 second. You guys can't see it because I didn't bring it up. Okay, let me read it. Bring up the letter. Okay, because I'm about to say, you guys, if you are on TikTok, you have to come to my page to see it. Let me see which letter we are in. In fact, there's some things. Let me close up some stuff so I don't open some stuff unintentionally. Okay, so I'm gonna close this. I'm gonna close this. All right. What about this? Okay. Okay, so this is the one. Yeah, that's the one. What about this? I'm going to close this. Okay, this one could stay. Okay, that's you too. Okay, good. All right, good. Okay, so. All right, so I'm going to read her letter. Yeah. Okay. Let's go back. All right, guys. Sorry. I just wanted to make sure I have the right one. Sorry. I have some, my chin is bothering me. All right. I'm going to read it again. Dear Judge, I have been in a cycle of thoughts and then over thoughts writing this letter to you. If there is one thing I have learned from this experience is that victims and survivors will never be safe. Although I can hope for justice and accountability, I've come to not trust anything. I hope that your decision considered the truth at hand that the jury failed to see. They didn't want to see it, my love. They just didn't care about the women. For 4 days in May, while 9 months pregnant with my son, I testified in front of a packed courtroom about the most traumatic and horrifying chapter in my life. I testified that from the age of 19, Sean Combs used violence, threats, obstinance, and control over my career to trap me in over a decade of abuse. He groomed and to perform repeated X act with hired males, ex workers during multiple days of F and the letter O, which occurred nearly weekly. I was forced into lingeries and heels, told exactly how to look, plied with rugs and drinks so that he can control me like a puppet. These events were degrading and disgusting, leaving me with infections, illnesses, and days of physical and emotional exhaustion before he demanded it all again. X Act became another my full-time job, used as the only way to stay in his good graces. I tried to tell everybody that you said this in court, but they didn't want to listen. I testified that I learned to read Sean Combs' signal, knowing that when he spoke of the F and the O, he was demanding them, and that refusing meant punishment. That means losing my car, my phone, or worse. He controlled every part of my livelihood and threatened to destroy my reputation by leaking X tapes, a threat he repeated often. His power over me eroded my independence and sense of self until I felt I had no choice but to submit. When he believed I had wronged him or was not sufficiently responsive, he also threatened people around me and those close to me, including my family. I regularly worried that displeasing him meant putting my family and friends' safety at risk. I testify, however, beyond these threats, Sean Combs frequently used violence to get his way. Over the nearly 11 years we were together, Sean Combs would pop, pop, put foot on face, the hair, the body again on floor and walls. The jury saw pictures of the bruises on my back from Combs putting foot and saw the deep gash on the eye he caused when he, you know, on the bed. The entire courtroom watched actual footage of Combs' foot and pound me, and as I tried to run away from a F and an O in 2016. I told you that was an F and O. People don't want to believe that, girl. They want to believe that you took his phone and that he wasn't doing anything to you but sitting there and staring at you, and that the reason why he got mad is you took his phone. People watch this footage dozens of times, seeing my body, on the ground, my hand over my head, curled in the, to shield from the worst. This violence caused oozes that, wanted to make sure they didn't, sorry guys. That makeup artist paid by Sean Combs would cover up, as well as permanent scars all over. During my time with Combs, I was in constant state of hypervigilance, as I was always anticipating demands of X act and otherwise fearing retribution for any perceived slights. My descent into substance use was directly correlated with his increased control over my body, my money, my freedom, and my free will. I used those rugs to push through the horrifying acts he demanded, and to numb myself to the physical and emotional. I was constantly in. While the defense attorney at trial suggested that my time with Combs was akin to a great modern love story, nothing could be further from the truth. Good girl for using that, saying that, repeating that. Nothing about the story is great, modern, or loving. This was a horrific decade of my life, stained by abuse, violence, force, and degrade. I spent the last 7 years of my life slowly rebuilding myself, physically getting clean from the rug, Sean Combs, um, us encourage and mentally understand how to live with a seemingly insurmountable level of trauma. The horrors I endured drove me to have thoughts of, unalivement. One I almost followed through on, if not for my family's intervention and urging that I seek professional care. I have been to rehab and have taken part of dozens of type of therapy, modality to confront, compartmentalize, and cope with the horrific memories of actual and emotional abuse I endured for nearly 10 years. While what he did to me is always present, I am slowly learning how to live my life free of fear and horror I endured in doing so, and fully devoted to my husband and my children. I still have nightmares and flashback on a regular, everyday basis, and continue to require psychological care to cope with my past. My worries that Sean Combs or his associate will come after me and my family is my reality. I have in fact moved my family out of New York area and am keeping a private and quiet as possible can, because I am so scared that if he walks free, his first action would be swift retribution towards me and other who spoke up about his views and trial. As much progress I have made in recovering from his views, I remain very much afraid of what he is capable of and the malice he undoubtedly harbors towards me for having the bravery to tell the truth. Yeah, he does. He does. So does his people. So does the black women of America. So does a lot of content creators. So does Dave. They all resent you and Jan and the other ladies because you went after this black male of excellence. They refuse to see the truth of what happened to you, Cassie. And I'm sorry about that. I am very, very sorry about that. His defense attorney claimed he is a changed man and he wants to mentor what girl. I am trying, like I told the people on DJ Creed lives, I am trying to be less angry about this. I am trying to bring myself in a moment where I could say, okay, maybe he could try to help men with their issues. I am trying so hard. But girl, the fact that you put this in your letter just shows you that I was right to feel away. I feel such a way about this. And everybody tell me I'm wrong. Okay. His defense attorney claimed he's a changed man and he wants to mentor abusers. I know firsthand what real mentorship means, and this disgusts me. He is not being truthful. Yes, girl, I said the same thing. Girl, I said the same thing. Girl, I said the same thing. Cassie, I said the same thing. Cassie, I'm not even you, and I said the same. I swear to God, I said the same thing. I said that to the same people over and over again. I said, how can he do it when he's not even being truthful? He's not holding it accountable. He's not taking responsibility. It's all about a show. It's all about BS. Girl, I said it. And everybody said I'm a liar and oh my God. Not that I'm a liar, but that I'm unforgiving. And Christians forgive others, and we should give him an opportunity to change and be, oh my God, girl. I'm not even you. And this first two lines just hit me in the heart, boy. I said to say, oh my God, let's continue what you had to say. Oh my God. It's almost like you and I are friends, girl. It's almost like you and I met each other. It's almost like you and I know similar people. That we've helped different people who suffer through the same crisis that you suffered through. And I can tell the difference between somebody who's 100% trying to make changes and somebody who's bullshitting. Girl. Woo. I'm going to read this again. His attorney claims he's a changed man and he wants to mentor users. I know firsthand that real mentorship means, and this disgusts me. It disgusts me too. He's not being truthful. I agree. I know who he was to me. The manipulator, the aggressor, the users, the trafficking is who he is as a human. I said the same thing. He has no interest in changing or becoming better. He will always be the same cruel, power-hungry, manipulative man that he is. I said the same thing, girl. I said the same thing. Oh my God. I said it word for word. I got to look for the video. I gotta look for the video. I gotta look for the video of when I said the same thing. I said the same exact words about this fool on DJ Creed Live. I said the same thing about I gotta go on DJ Creed Live and read this statement directly and ask them if they remember this is exactly what I said verbatim. Verbatim. When I came out with my allegation and my civil, he flat denied them again and again. I said that too, girl. It was only actual video footage corroborating the exact word in my civil complaint that he issued an insincere apology on the internet. I said the same thing. Oh my God, she must have watched me. She said that. That's it. I'm claiming that she saw everything I said because there's no way. I've never met you a day in my life, and I said exactly the same word for word. It's almost practically word for word of what she wrote here is what I've been saying in all these lives. Oh God. It just validates, even though people disagree with her and think that she's lying, this entire paragraph validates everything I've said. And I don't know this woman. I've never met this woman a day in my life. I probably never meet her. But I said everything, all of this over and over again. Thanks to the footage in my testimony, this is also something he will never forever be associated. And I said that too. I said that too. I said, I don't care. Everybody's like, oh, you're upset because he got found. I'm like, we got 2. It was 5. He got 3. We got 2. I say I'm satisfied because no matter what happens moving forward, he will always be associated with all these horrific things that he did. Always. He will never be able to clean the dirt that's on him. Oh my God, girl. Oh, that whole paragraph. I gotta read this whole paragraph is my paragraph. This whole paragraph is my paragraph, girl. What? Oh, he mad. I know he mad. He mad. Oh, he mad. For over a decade, Sean Combs made me feel powerless and unimportant. But my experience was real, horrific, and deserved to be considered. While the jury did not seem to understand or believe that I engaged in FR because of the force and the coercion and the defense used against me, I know that is true. Of course, the jury is stupid. They're a bunch of idiots. They're a bunch of idiots. And I'm sorry. I'm sorry to say that a bunch of 12 jurors, these juries was wrong. They were wrong. And we're going to know it because they don't stop. Serials don't stop. He'll start again. He'll do it again. He'll do it again. I promise you. When he gets out, he's going to continue doing this lifestyle. He's going to get caught again. He's going to get caught because he's not going to be able to help himself. And if he move on, transition to another life, they're going to find videos, movies, books. His people going to come out talking about the real story, and they're going to want us to understand after that because they're going to come out and they're going to talk. I promise you. Because they're not going to be able to help it. If they don't talk their families or their future generation, the truth would be told. and you would be vindicated across the board. I promise. I know that is true, and his senses. Okay, engaged in it. I know that is true, and his sisters should reflect the reality of the evidence and my lived experience as a victim. Reliving in detail the events of truth described throughout the trial in this letter causes me tremendous emotional pain. And I said that too. I said people don't want to understand. I said this woman had got money, and this is what the prosecutor says. And I'm glad she wrote this letter because it also shows that the prosecutors did the right thing when they did this because they were protecting the survivors. This letter clearly says that. Because let me tell you something. I said over and over and over again that this is I said over and over again that she was a victim. A lot of people didn't believe it, but I said that she was a victim. I said that he was not regretful. And I said that the jury got it wrong, right? I said all of this. And this letter is just validating everything that I've said, right? I've said everything in this letter. Everything. And I know and I hope that one day the truth will come out. And once people stop being so enamored with him, they're going to start looking at him for who he really is and how he treated these women. Because he never truly took accountability. He never truly said sorry. He never did. He always saying that, oh, it's just just this and just that. I am trying with all that I can to move on. I hope that your sister's decision reflects the strength it took for victims. Amen. Of Sean Combs to come forward. I hope that your decision considered the many lives that Sean Combs have ended with his abuse and control. I thank you for your time and attention. Cassandra Ventura Fine. Go ahead, girl. Oh my God, this letter is everything to me. This letter is everything to me. This is pretty much everything I've been saying. I don't know this man from a can, from nothing. I don't know him. I just know him. I see him, but I know survivors, and I know she was telling the truth. Oh my God, this letter. This letter. Of course, a lot of people are going to still call you a liar. I remember what I was saying. The prosecutor says that she got $30 million allegedly from everybody. She got 20 for one, 10 million. There's no reason why the Cassie Ventura Fine needed to come out and tell the story. There was no reason. None. She could have lived her life. Thank you for this letter, Cassie. And I hope that the sentence does reflect what he did. All right, so here's another letter. I believe this one is from I think this is from the hairdresser, Dante Nash. Let's read this one. Oh my God, that letter was powerful, guys. Sorry, my face is all in the camera. They're like, why your face so close? Sorry, my face is all in the camera. Let's read her. Let's read this. Yeah. Okay, let's go. September 29th. Dear Judge, thank you for the opportunity to share these thoughts. I write with great respect to the court and difficult decision it must weigh. Mr. Cohen attempts to secure release before his scheduled sentences hearing demonstrate a troubling lack of accountability and a continued pattern of manipulation. I agree. The charges he was convicted of, including violating the Mann Acts, are not minor. Thank you. They reflect serious, deeply disturbing conduct involving the coercion and transport of individual for not actual activity, not good, not legal actual activity. The thought that Mr. Cohn does not believe he deserves jail time is both disturbing and frightening. It underscores the depth of his lack of accountability and the danger he poses. Someone who refuses to acknowledge the harm they have caused, who believe they are above the law, demonstrate the same pattern of manipulation and abuse that has impacted so many lives. The fact that Mr. Cohn believed that because he did bad things to people he claimed to love or call friends he somehow deserved leniency is outrageous. That sense of entitlement make his action even more so. I completely agree with you. Everybody's saying I'm crazy. Everybody's thinking I'm cuckoo for cocoa puffs. I completely agree with you. Yet Mr. Cohn continues to treat this process as negotiable. Exactly, like he should. He's think he's the shit. He's the man, as though he is merely managing a legal inconvenience rather than confronting the consequences of federal. Thank you. Oh my God. Thank you. Thank you for that. And his people are doing the same thing. So is his supporters. It's like, it's not a big deal. It's just a little tuition. It's just private. It's just a little DV. Why should you take everything away from this great man? Thank you. These letters, man. His efforts to preempt the court process should not only show not only a lack of respect for the justice system, but also show the refusal to acknowledge the severity of his action. He doesn't care. At one point, there was a public indication that Mr. Combs intended to seek professional and mental health treatment. Whether that ever occurred remains unclear. What is clear, however, is that there has been no visible movement towards accountability. Yes. Rather than allow the legal process to proceed in good faith, he has focused on tactical maneuvers, yes, meant to bypass scrutiny and maintain control. Soliciting letters of support. Well, that's expected. Crafting PR statement, yeah, and attempted to manipulate public sentiment. Yeah, that's on them. That's not us. That's not everybody. His plan to escape accountability has been in motion from the very start. Yes, I see it very clearly. His islands has not been limited to private encounters, from orchestrating the F and the O to assaulting on staff and strangers. His behavior has a long trial of ixdom. Many of them still live in fear. Some of the worst was inflicted on people he claimed to love. This is not the story of one or two isolated incidents. This is a story of hundreds, possibly thousands of people whose lives have been scarred by his unchecked power, and people don't care. I'm brutal. People don't care. People don't care. They're still trying to get more money. They're still trying to get his attention. Mr. Foe must also refrain from comparing his crimes to those of others. His conduct stands on its own and has set a new legal and cultural precedent. So true. So true. So true. Pop, pop, pop. Fingers right there. Fingers right there. This is not about relative wrongdoing. It's about an individual accountability for a decade-long pattern of abuse. There are many reasons why Mr. Combs should serve an appropriate sentence. So, I love the way that you bullied it. Go ahead, boy. Go ahead. Psychological impact on victims. His release would re-traumatize survivors, many of whom remain in hiding for their safety. The court has a duty to uphold justice and protect those speaking out. Influence other potential co-conspirators. Release would allow him to coordinate with uncharged associates to retaliate and construct false narratives. Beautiful. No remorse or accountability. Number one, I said this. Today, he has shown none. No genuine remorse. Also, carefully crafted statement included under legal pressure. This lack of accountability should weigh heavily against any request. Yes, public safety concern. The allegation among Island's physical abuse, certain unalive threats, intimidation. His release would make it unsafe for survivors in the public at large. I agree that 100%. Beyond legal concern, I want the court to understand the very real live impact of Mr. Combs' abuse. This man harassed everyone around us, including friends and business associates, so relentlessly that people no longer wanted to work with us or even spend time with us. We were ashamed to leave the house. Yes, you were. The balcony he hung Bama from, a place that once offered peace, became a site of terror. The home he held me in against my will was my own. The keys and phone he stole were possessions I earned through years of hard work. He robbed me not only of safety but of dignity. Lord, baby, I'm sorry. He reached was suffocating. He has caused lasting damage to the lives and career of nearly everyone in his inner circle, past, present, and likely future. Some complied willingly, many more felt coerced. He taunted victims through songs that contradict the truth, creating false narratives that could never safely be challenged because of his fear, the fear he's instilled. He pursued Cassie through his friends, despite both of us telling him she wanted no contact, and tried to manipulate the situation by offering favors if I helped deliver her to him. God, Lord have mercy, blessed. He has openly declared to his victim that he does not respect or care about the legal system. If he does not respect the court should not extend him any leniency. I do this not just for myself, but for every mother, father, child, grandparent, sister, brother, boyfriend, husband, wife, friends, artist, intern, employee, and assistant who sacrificed for a man who only abused them in return. Please, wave hand. Wave hand, wave hand, wave hand, my brother. Oh, I have watched people take trains, move across the country, leave their family, and dedicate themselves fully, only to be mistreated, exploited, and silenced. Some of these same people have even left the entertainment industry entirely because of his actions. Yeah, he wouldn't have got me to do that. I'm just telling you, it would have been a situation, boy. He ain't gonna like me. I'm just telling you, it would be a situation. It just would. This issue is not only about violence; it's also secrecy. Many of us were abused precisely because Mr. Combs wanted us to hold his secret to maintain his reputation. The truth is, Mr. Combs never respected those who worked closest with him. Woo! Yeah, I know that. I know that. He cheated on. I hope that you start releasing stuff on some KK, because KK is an ass. Let's continue to support this fool. He rummaged through our lives while publicly pretending to suffer through hard time. He refused to take responsibility, privately or publicly. The abuse was deliberate. The control was relentless, and the damage is lasting. Oh my God, I love this letter. The same element Mr. Combs now claims as an excuse are the very ones he has carried with him throughout his years of touring, conducting business, and abusing those around him. They never stopped him from being violent, abused, intox when left to his own devices. They should not serve as an excuse now. True change cannot exist without acknowledging the harm one has caused. Claiming to have changed while continuing to deny the very behavior that leads to incarceration is not accountability. I said that over and over again. Oh my God, everybody thinking I'm lying. They're like, oh, no, Mama Flip. He's trying to change Mama Flip. He is being held accountable for Mama Flip. Didn't you hear that he said he was sorry, Mama Flip? Didn't you hear he said he was sorry? Of course he's being accountable. Why you said that, Mama Flip? Mama Flip, you so wrong to say he's not accountable. Boy. Oh my God. Mr. Combs repeatedly shifted between denying responsibility, seeking sympathy, and reshaping narrative to suit his immediate need. Thank you. Real transformation is consistent, honest, and uncomfortable. It does not depend on who is watching or what outcome it desires. Thank you. Until he confronts his actions as wrong and takes full responsibility, any claim of change is hollow. Thank you. Oh my God. I do not expect him to be in jail forever, but I'm praying for a sentence that allows the victim to heal and encourage Mr. Combs to generally change. Yes. Yes. For all these reasons, I respectfully urge the court to deny his request for early release and to deny his 14-month suggestion. He's been fighting the truth for the past year, and this ongoing denial is causing additional harm to the mental well-being of his victim. Survivors deserve safety. The public deserves protection, and justice demand accountability. Judge, this is not a good man. Oh, God, thank you. Thank you so much for your time, Judge Iran Sabarian. I can't pronounce his name. Your consideration mean a great deal to me and to the victim, respectively. That's it. Oh, that was beautiful. That was beautiful. What? That was a beautiful letter. I swear. Go ahead, you people. Oh, I'm so proud of you. I'm so proud of you. I'm so proud of you with this letter. I'm so proud of you with this letter. I really am. I'm so proud of you with this letter. Oh my God. I've been saying all this. It's so wonderful to be able to just hear these people come out and say these things, because sometimes it feels like you are all alone fighting all alone, because everybody's out here believing this man. They just so enthralled with this guy that nobody wants to take the time to really see what's going on. They don't, and nobody could come and say, "Oh, yeah, I'm lying." I'm not. Nobody really cares for these victims. They don't. Nobody cares for these victims at all. The only people that cares for the victim is people who cares about victims as a whole. They don't care about these victims, and it's sad. Trying to see if I could get the other letters. Trying to see if I can get the other letters, guys. Hold on 1 second. I know where they are. I saved them. I don't know if I could get them this way because the files. Oh my God, that letter is amazing. No, that's not what I'm looking for. Okay. Okay. Okay, I think I got the folder. I'm trying to see if I can get. Oh, but the thing is, it doesn't help unless I bring them up here so you guys could see it. Hold on, guys. All right, you guys, I have to bring it up here so you guys could see it. I have to go back to X. Okay. I have to go back to X, and I have to find these emails to see if I can bring it up. So give me 1 second, guys. Let me see. All right, her. Okay, good. Hold on, guys. She has a bunch of letters. Let me see if I could get them all. A federal prosecutor. Okay, so let's see here. I don't know if I could shoot. I don't know. Can I make this bigger? Like, the thing is, I can't read. Even if I make it bigger, I can't read them. It doesn't help. Give me 1 second, guys. I'm trying to see. I can't read her letter. Woman, I know you did the PDF. She has a PDF of all of these letters. So let me see if I can. This is judge rejects Diddy motion credit sentence is scheduled for Friday at 10 a.m. Okay, this is Cassie Parrott's letter. Okay, woman, where's the link? This is hold on. Okay, judge, this is not a good man. Okay, I have that. She got the storage. I have that one. That's the storage one. Okay. Here's the first 4 letters of PDF. Okay, hold on. Okay, we have that one. This is prosecutor recommending 130. Okay, prosecutors recommend 135 pages, guys. 135. Um, that's 11 years and 3 months. Hopefully he gets as much. This is Mia's statement. Okay, I see Mia's statement, man, but is it possible? This is saying for me that all of the things that people heard, two counts of okay. This is Capricorn. Okay, Capricorn wrote a letter. Okay. Um, shoot, I'm trying to see. I think all of them. Okay, it's gonna be hard for me to read these letters. Let me see if I could read them in a new tab. Let me see. Oh, okay, good. Okay. Okay, okay, yes. Okay, this will work. Okay, good. All right, guys, let's do Capricorn letter. Okay. Um yes, okay. Okay, guys, so this is Capricorn letter, right? And I could, if I put all of these files, I could bring them up. That's what I did. I actually typed up all these the numbers and then brought it up, but I don't have time right now. Okay, dear judge, I testified in your court in this case in May 2025. Have you heard I worked with Puff from 2004 to 2012, and during that time, I got to know him very well. Since Puff fired me in 2012, he has had me blacklisted from the industry, and I've had to take multiple jobs to garner multiple jobs to garner anything near my word. Today, I'm a single parent and a non-verbal autistic little boy living in Los Angeles. The ordeal has taken 14 years of my life. My career trajectory halted at 33 years old. But I lived through working with Puff, and in particular, the events of December 2011 altered the course of my life and had haunted me for years. I feel that I had paid with my life for the events that transpired that fateful day we had to relive in federal court. I've never wanted this. For many years, I could not tell my story, and I lived in fear of Puff and fear of how I would feed my son. About a year and a half ago, HSI case agent found me and asked me what happened. Those agents changed my life, and I would like to say that the Southern District of New York is the epitome of prestige and professionalism. I was handled with ultimate care. Thank you for saying that. By testifying publicly in front of Puff and his supporters was one of the hardest moments of my life. Every last word you heard from me was the truth. Yet I felt, and to be honest, still feel like I had to fight to prove that I am a victim. Girl, yes, because these people are heartless and they don't believe that you are. You're right. You still have to fight because they think that you lied. Yep. Because the purpose of napping me wasn't for traveling. What it was for was something more serious, more sinister and grave. Violence and absolute power, unchecked in the ultra rich and famous. Thank you. It's the saying to me that all the things that people heard, two constitution of man is the only thing that remains on the table. Yeah, that's exactly what they did. That's exactly what they did. I wanted to speak up, tell the truth, and to do the right thing when I was asked to testify. But I am afraid that women and girls in America feel less protected than ever watching what just happened. I agree 110%. Because you have to be a perfect victim, though, right? You have to be perfect. You can't be flawed, according to certain people. It's according to even other survivors themselves. You cannot be flawed. You have to be perfect in order to even consider it. The reason seemed to be that we should not speak up, not call law enforcement for help, and not say anything, but instead keep our heads down and try to make a way, regardless of what happened to us. I am afraid that this may be the only realistic way to proceed in the modern world. Well, I think everybody, well, I, I, I don't know. This case messed me up too. So I don't know. I don't trust the world. I totally don't trust the world. I the last ray of light is that you provide justice to us. Yes, you have a chance to finally help him know that he can't just do what he wants to people. There are repercussions and consequences. He cannot just destroy other people's lives. Karma will come back to 100 times fold, 100 times ways. I would like Sean Combs to serve additional time in the correction facility. I truly believe that serving more time will save Puff life, as time away from money, rugs, and power is the only punishment he will recognize. Preach. I hope Puff has life on the other side of the time to make good on the changes he knows he has to make, to spend time with his family and get a chance to correct the damage that he's so recklessly done to so many people who only meant well by him. Go ahead, girl. I really appreciate this letter. Um, Thank you, Your Honor, for your time, consideration, and for hearing us. Finally, God bless Capricorn Cloud. Go ahead, Capricorn. Go ahead, Capricorn. Go ahead, girl. Go ahead, girl. I'm so proud of you for writing this letter, girl. You have no idea. I don't care what these. I am so proud of these survivors. Nobody even understand how proud I am of these survivors. All right, so let's see Mia's statement. Oh, I'm so proud of these survivors telling their story. Let me see. Oh my God. Let's read Mia's, because everybody think you're a liar, girl. They think you're a liar. They think that you're fast. They think that you're a liar. They think that you wanted him and his gloriousness, desirable and gorgeous and fabulous, that you just wanted to have him, and you lied because you were afraid. Telling your friend the truth will destroy you, or that you so mad that he didn't give you your own show and that you are such a hated kid. Apparently that's what they think about you, my friend. Apparently that's what they think. That's what they think. They think he's everything and you're nothing. So let's read Maya letter. Your Honor, I am writing to you on behalf of my younger self, a little girl who once dreamed without fear, who believed the world was full of possibility, who had faith in the goodness of people, and who trusted that her hard work, big heart, integrity would carry her towards a bright and meaningful future. That little girl is gone. She was buried alive by a user, trapped in the world of error, use, humiliation, and cohesive control. This letter has been excruciating to write. Other than during my testimony, I've never had the courage to discuss my views publicly. It feels impossible to describe that I'm slowly just beginning to unravel the tangled web of trauma of myself, but I decided that it's better to try to describe the permanent damage that Sean Combs, my user, has caused me rather than to remain silent any longer. I began working for my user in my early 20s after I moved to New York City with only a mattress in my car and a dream in my heart. I was made to believe that it was an opportunity of a lifetime to work for him. I was young and naive. I wanted to make a name for myself. I wanted to change the world for the better through my creativity. My dream was to one day become a writer, producer, and performer. In those early years, I was hopeful and innocent. From the start, however, my user, uh, my my abuser preyed on that innocent. I'll just say user, guys, because I don't want to get in trouble. And what I thought was a once in a lifetime opportunity gradually became a never ending nightmare. I experienced manipulation, humiliation, coercion, and violence. I was groomed, exploited, and broken down. He stripped me of my freedom, my safety, my identity, my instinct, and my autonomy. He alternated reward and punishment to break down my self worth and instinct, creating dependency and confusion. He dangled my dream before me like a carrot, promising opportunity, mentorship, achievement. He controlled every part of my life. I needed his permission for everything: when I could sleep, when I could eat, when I could go use the bathroom, when I could go to my room, even when I could buy tampons. He created a life where nothing was mine, and I lived in constant fear because his mood would determine my right to exist. Asking for compensation for my labor, including overtime requests or reimbursement requests for work-related expenses, would lead him throwing a tantrum, yelling, and sometimes throwing objects in my direction in effect to humiliate me. He framed my request as stealing and made me ashamed to expect any income at all. Though this financial manipulation, he can't through this financial manipulation, he kept me dependent and trapped. My work for the defendant was not a job; it was a captivity. Girl, his cohesive control and unpredictable islands left lasting psychological score, anxiety, hypervigilance, disassociation, self-doubt, and an ongoing struggle to reclaim my autonomy. Years of use has rewired my brain. Even today, I feel trapped in the mental and emotional pattern that he created. I live with chronic and severe PTSD, depression, and crippling anxiety. I suffer from deeply intrusive thoughts, um, derealization, panic attack, night terror, insomnia. When I can get a few precious hours of sleep, those hours are all often filled with night terrors that wakes me and a headache, sweat, screaming and crying. I wake with heart pounding, gasping as I am still trapped. I am struggling to feel safe in the workplace because of PTSD, which had resulted in fragmented professional record, a bankruptcy application, and gaping debt. I can't go to many public um, places I loved. Hold on, I have to go to read it, bring up the other letter. Oh, girl. I'm gonna stop. I have to stop this one and open up the next one. Mm, 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 mm. They don't understand, girl. They don't understand. They don't want to understand. The anticipating of terrifying was also horrendous. My therapy session was spent bracing for the unfermentable moment that I would face him in your courtroom instead of focusing on rebuilding my life and forging a new future. When I tried to imagine walking into that crowded courtroom and facing him, I would black out. For months, I suffered from panic attack. My tongue swollen, my stomach dropped, my hand was cold, my leg became numb. I couldn't sleep, I couldn't eat. The feel of dread and terror was so intense, I couldn't hide it. I would randomly bust into uncontrollable childlike sobs. I found myself self isolating for fear of being a burden on the people I love. I didn't know how to ask for help. I didn't know how to say I was not okay. I had been conditioned for so many years to believe that my needs were unimportant, that my emotions were forbidding. If I expressed any indication that I was suffering or well, I would be in imminent danger. I wanted to jump out of my skin. I felt relentlessly ashamed. There were times when I did not want to be here. As a result of the defense team tactics during my testimony, and despite my use of my pseudonym, my identity has been publicized. Girl, I haven't said your name since. I haven't even said your name. You still Mia to me. Has been publicized. And my name is now no longer my own. It is forever linked to my abuser. Of My sweet, loving parents had to read horrific. Oh, I'm sorry, horrible details about the use of their daughter, riddling them with anxiety and leading them to unfairly question themselves as if they could have done anything to prevent this. And everyone I have known and everyone I will meet will now know my darkest moments. Even the children in my life, my sweet niece and nephew, and my loving goddaughter and godson, my friends' children who inspire me to tell the truth, will one day read the vile detail of my use. Although the verdict fell short of justice I hoped for, the defendant is still found guilty of serious. Yes, girl, yes, you and I feel the same way. At least we got two, girl. At least we got two. At least we got two. What he stole from me cannot be returned. It cannot be reduced to years of money. He stole my freedom, my sense of safety, my ability to trust myself and others, and my confidence. He stole my dreams of having a stable, healthy family of my own, my career trajectory, and both my creative work product and creative aspiration. He stole 16 years of my life, time I should have spent developing into an independent woman I was I was meant to be. My life has been profoundly broken. I am pleading on behalf of my inner child, a sweet, hopeful, bright-eyed girl who could not survive the defendant abuse, and for the woman I have become, who was robbed of her future. I'm pleading for the brave victim that come forward and the countless, oh my God, these letters, these letters are everything. Lord have mercy. These letters are everything. Other victims who continues to suffer, who has been scared into silence. The defendant has shattered many lives, and they too deserve justice. They too deserve to live without shame or fear. Victims of actual, psychological, and violence crime, especially against women, are often forced to prove themselves by reliving the very trauma that destroyed them. We are questioned, doubted, humiliated, and re-victimized as if surviving and coming forward to tell the story of our survival make us suspect. Exactly. We are forced to serve a life sentence for living with the consequence of the defendant use every day. Exactly. Finally, I'm pleading on behalf of future generations who deserve a world where editors cannot escape accountability. Exactly. Your Honor, I ask that you do justice through the sentence that you imposed on October 3rd, 2025. The defendant's wealth, power, and fame should not place him above the law. Exactly. The forces have shielded him far too long. I ask you to deliver the sentence that reflect the full measure of that he has caused, the years of coercion, financial abuse, humiliation, physical, sexual violence, the profound trauma that he inflicted as a result. I ask you to deliver a sentence that takes into account the ongoing danger my user opposed to me and others. The sentence that honors the truth, the pain, the lies that he has destroyed. The sentence that gives us hope, protection, and justice. Please help us believe that the legal system can offer justice to innocent and vulnerable victims. Those with power, wealth, and influence cannot destroy lives without consequences. Help us believe in a world where survivors are heard, believed, and protected. Help us restore the belief that good can prevail. Help us ensure that no one else suffers as we have. Help us believe that justice can and does exist by holding our user fully accountable. Please, Your Honor, you have the power to show us the world in the future that our lives, our voice, our truth, and our humanity matters. Please help us with gratitude, respect, me. Oh my God, me. Oh my God, Mia. Oh, yes, girl. Yes. Yes, girl. Yes. That letter is beautiful. Oh my God. I hope he listens. I hope the judge listens though. Oh my God. These letters are everything. These letters are everything. And I hope you guys, all of you guys, get the justice you deserve. I hope you guys get it. Lord have mercy. Mm, 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 mm. So yeah, wow. Yeah. Federal prosecutor one former assistant who testified on trial under the suit to speak at his sentencing knowledge. She's not a statutory victim of the offenses of conviction. Oh, she wants to come out and talk. No, don't let her do it. Leave her alone. Let the baby. She has to come out and you want her to talk again? Oh my God. Oh my God. Oh, I don't know if I can take it. I don't know if I can take y'all coming back out and I don't know, guys. Oh shoot. Okay, I want to read Cassie's parents' letters too. I don't know if I could take it seeing you again, Mia. I don't know if I could take seeing you again. All right, so let's read Cassie's parents' letter. I don't know if I could take seeing her. I think that would hurt me just to see her again, boy. Seeing her every day there was like a lot, guys. So okay, so hold on. The Honorable Judge, he has the address. Dear Judge, we are writing to you extremely concerned parents regarding the upcoming sentences of the defendant referred above. We have read many online reports that state that months are being suggested for his punishment and sentence as opposed to the many years that we feel he deserved. 11 years is the length of time this horrific nightmare lasted. During the time, our daughter has been repeatedly was Papa repeatedly exposed to harmful and copious amount of drugs. She was held like a prisoner, napping by the defendants when her first told the story of eating. She was coerced to perform acts with strangers and institutes for the defendant own actual gratification. I'm sorry, guys, I have to read in code. None of the actual acts was consensual, so there is no consent in a domestic DV relationship. I'm sorry for saying that. There is also the of Allen's. Everything she did with for and because the defendant was self-preservation. She was, in actual fact, utilized by the defendant power and depraved. Our daughter is dealing with psychological, emotional, as well as physical aftermath of the use she endured in the hands of the defendant. She will be left to deal with the trauma the of use far beyond 27 month sentences with time saved, as suggested by the defense attorney. We believe the charges with the defendant was convicted was not only federal crimes, but they are also severe violation human self-worth and freedom. Clearly a vile use of power coupled with immense disregard of human life. The sentence lightly in this case that involves such vigorous use of our daughter body, safety, and dignity is to dismiss her very existence. To sentence lightly would also send a dangerous message. A sentence that is handed down in months instead of years sends a message that such repulsive behavior can happen without meaningful consequences. In closing, we, her parents, urge you to deliver a sentence that's appropriate, reflect the severity, deprive of use, the breach of trust, the suffering that our daughter experienced. The justice system must be placed where the voices of those who have endured actual and physical use are heard, believed, and honored with appropriate accountability. Thank you for your time and your consideration. Sincerely, Regine and Roderick Ventura. Cassie Ventura finds parents. They say dash victim one. Oh my God. I've never. Mm, 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 mm. So I think those are the letters that I saw. I don't think there is any more letters that I saw, guys. I don't know. I just don't understand how other survivors don't see what many of us see. I don't know. But I think that's it. Those are the only letters. I'm waiting to see if Jane come out with a letter. I don't know if she will. Apparently, they're gonna allow him to wear regular clothes. I love this right here. I love this right here. I want to read this because this is so true. This is what a lot of people are saying, so people can understand why a lot of us feel that. I mean, the people who really feel something, because other people really don't care. But this is a prime example of why people feel a certain way about this guy, right? Hold on, I want to make sure. The court should be dubious. Let me read this part, and this is on X. The court should be dubious of counsel represented that the defendant is committed to leading a completely law-abiding life. He will never again engage in any type of conduct that come close crossing the lines into criminal conduct. The record indicates that the defendants will say anything with no regard to truth as long as he stands to benefit. For instance, in May 2024, when the video surveillance of the defendant assaulted assault on Ventura at the Intercontinental Hotel was leaked to CNN. The defendant took to Instagram, where he claimed that he took full responsibility, went to therapy and rehab, and asked God for mercy and grace. The defendant then committed to be a better man. Barely 1 month later, after the defendant committed to be a better man and fully aware that he was the subject of a federal investigation, the defendant um, um, kicked down 5 doors in Jane's home, lifted Jane off by the in a hole, pow in the head, foot on Jane, rag her by the hair, popped her that she couldn't stand, and then invited male over for a what is called now a hotel night. Clearly, the therapy and rehab didn't work in March 2016, and there is no reason to take the defendant in his word that he has adequately addressed his addiction and mental health issues. Girl, woo, while spending barely a year in the institution that the defendant claims erroneously, as explained before, is so violent and inhuman that he deserves a reduced sentence. Lord, rather the court should see counsel representing for what they are, lip service. Go ahead. Ooh, sa. Go ahead. That's right. Read them the right act. Read them. Lord have mercy. All right, I gotta go to bed. I think I read everybody's stuff first hour. I think I read everybody. If we get more letters, I will read it because I would like to read it. Me a statement. Capricorn letter. I want to read everybody's letters, so we'll see if more people come out with letters. So far, those are the only letters we have. I hope we get a letter for Jane and for yeah. Yeah. I hope that we get more. Hmm. That's okay. There's a story about somebody who was found not guilty of an act. It's okay because they won't stop. Like that's the thing I've learned when it comes to these people. They won't stop. Anyway, guys, thank you. I've been here all night. I didn't expect to be doing this all night. Sorry, my nose is itching and everything. I didn't expect to do this all night. I read it. I wanted to make sure I read almost everything. What's going on because the case is on Friday. I'm planning to be there. God willing, like my mother says, nothing happened before then. I'm planning to be there to see it in person. And no matter what happened at the court day, I hope we get a good sentence. But no matter what, his life will never be the same, and that's all we could hope for. And as advocates, then it's going to have to be what it is. His life will not be the same, and who knows? I could be wrong, and he could change. I don't agree with it. I don't think it's going to happen. I think that he will not change, and I stand firm in my belief that he will not change. I think that a lot of stuff that he's planning on doing or talk about doing, he either not going to do or he's doing it for lip service just to get out of jail. I think that he's going to come out even worse than he was before. But again, that's me. If I'm proven to be wrong, then I will be more than happy to say that I was wrong, and to be held accountable, as far as saying, "Hey guys, I got it wrong." I just don't believe I'm going to be wrong when it comes to this guy, to be honest with you. But I hope the victims, the survivors, a few nights of peaceful rest, and I hope that they all get the justice that they deserve. All right. So thank you guys. Good night. Good night. Good night. Thank you for being here. Tickety Talk, thank you for being here. Instagram, thank you for being here. I appreciate everybody that sat here and listened to me read and go through this entire excruciating court document and try to understand it and give my interpretation. Again, if more letters come out tomorrow, I will be reading the letter tomorrow, and on Thursday before the trial, I'll be reading it. If not, then hopefully everything works out, and I will be at the courthouse on the 3rd to see it in person. All right. Take care, guys. Thank you so, so, so much for being here. Bye, Instagram. All right. Bye, Instagram. All right. Bye, Tickety Talk. Thank you for being here. Not too many people was around to hear, but for the people who actually showed up and stayed, I appreciate you. Again, I can't save the live, so if you guys want to see the live, please go into my YT page, the same name, and see the live all over again, because I'm not saving anything here, because for 6 months I'm not even playing around with Tickety Talk. They could have it. All right. Take care of yourselves. I will go on live to give you updates as best as I can using this platform. All right. Take care. Okay. Bye bye. Okay. Now, one last you the Tubi, thank you so much for being here. For everybody who was here, I really appreciate you guys. I definitely see attentively Lola. Thank you. I'm not sure if you're still here. You're probably not, but thank you for stopping by. And for anybody who later on watched this video, please like, subscribe, and share. I'm trying to get to 50 subscribers so that I could actually do an actual live on this channel to talk about what's happening. Right now I had 38. I'm trying to get to 50 so I could do lives, because I can't. I separated everything from from the main page, Mom Demand. What am I thinking? Lord have mercy. Flip slot channel, and then created this channel. So please, please, please consider to subscribe. In fact, Tickety Talk, you guys are still here. If you're on TikTok and you have YT, if you could go to MamaFlipLive's channel, and you'll be able to see this again if you want to. But I also need to have 50 subscribers, so it would be really great if you could help me get 50 subscribers. All right, so bye, Tickety Talk. Okay, bye. All right, guys. Again, thank you for I don't even know what the hell this is. It's probably I have nobody on Tickety Talk. Who knows? Anyway, thank you for being here, guys. And again, if you I'm sorry, I didn't mean to do that. Thank you for being here, guys. Really, really appreciate you guys. And I'm so tired. I really wanted to do this before the court date. So if there's more letters, I'll come back. Please subscribe. Please subscribe to my new channel. Everything that has to do with politics, entertainment, anything else is going to be done on Mama Flip Lives. No longer Mama Phillips, not Mama Flip's slot channel. That's only for games and plays and having good times. Okay, so please come to this channel, and hopefully you like what you hear and see. And the only at the end of the day, all I could tell you is my truths of what I believe and think on certain subject matters. So hopefully you're interested. Please help build up my channel. But if you love slot plays and games, you're gonna love our channel because we do a lot of that. Okay. Take care, guys. Okay, thank you so much for being here. Okay, bye-bye.